Good morning, everyone. I know that this court session was originally scheduled to be in person. I want to thank the litigants for their cooperation in moving this session to a virtual setting so swiftly. So thank you so much for your cooperation on this. I will call the calendar for the record. First case on the calendar is People versus Holder, and it is submitted. Rivera versus Haywood is submitted. G. Anthony versus Stephanie H. is submitted. Korn versus Sacco and Phyllis. Appellant Sacco gets 4 minutes and 1 in rebuttal. Respondent Korn gets 4 minutes. Callahan versus Haji and Ubertech. Appellant Callahan gets 5 minutes and 2 in rebuttal. Respondents Haji and Ubertech get 5 minutes each. People versus Taylor is submitted. KBS Shepherd Bay versus Terrapin Design. Appellant Terrapin gets 6 minutes and 2 in rebuttal. KBS, cross appellant KBS gets 6 minutes and 2 in rebuttal. Please put your microphone in mute. Thank you. Moon versus Cumby Ree is submitted. Gatwall versus Sieber. Appellant Sieber gets 6 minutes and 2 in rebuttal. Gatwall gets 6 minutes. G. Children is submitted. Labener versus Jerome Flores and 50 East 96th Street. Appellant Labener gets 6 minutes and 2 in rebuttal. Cross appellant 50 East 96th Street gets 6 minutes and 2 in rebuttal. Respondent Flores, Jerome Flores, gets 5 minutes. S. Scott versus Stephanie L. Appellant Scott gets 5 minutes and 1 in rebuttal. Respondent Stephanie L. gets 5 minutes. N. Ishaki versus D. Ishaki. Appellant M. Ishaki gets 7 minutes and 2 in rebuttal. Cross appellant D. Ishaki gets 7 minutes and 2 in rebuttal. Willoughby Operating versus New York City Economic Development Corporation and Brooklyn Partnership. Willoughby gets 6 minutes and 2 in rebuttal. Respondents New York City Economic Development and Brooklyn Partnership get 5 minutes each. Leibowitz versus Leibowitz is submitted. 227 West 61st Associates versus Waltham. Appellant Waltham 61 gets 6 minutes and 2 in rebuttal. Respondents 227 West gets 6 minutes. Rodriguez versus HPD and Stevenson Commons. Appellant Rodriguez gets 6 minutes and 1 in rebuttal. HPD and Stevenson Commons get 5 minutes each. Nugent versus City of New York is submitted. And Douglas Elliman versus TWP Real Estate, it's submitted. The first case on the calendar is Korn versus Sacco and Phyllis.
Your Honor, good morning, Cy Abner for the appellant, and may it please the court.
Good morning. We first hear from appellant. In this case, do we have an appearance for Korn?
Yes, Andrew Solomon for respondent Dr. Korn. Good morning.
Okay. Good morning. Okay, let me hear first from the appellant.
Your Honor, may it please the court, and happy holidays. Issues of contractual interpretation are legal in nature and can be considered by this court for the first time on appeal. Carnegie Hall versus the City of New York. If Your Honor exercises, if this court, I apologize, exercises its discretion and considers our arguments, I think there's only one conclusion. That is, the respondent did not meet his prima facie case for conversion of money because the assigning document, that is the underlying contract, does not specifically identify the personal injury case.
Counsel, this is Judge Owen. Counsel, this is Judge Owen. Didn't your client acknowledge the assignment, or am I mistaken?
It acknowledged it, but in hearsay, theoretically, and it was subsequently disputed before the end of the conclusion of the underlying personal injury.
Ask your question. That assignment, what was going on contemporaneously when that assignment was executed?
It's unclear from the record below.
How could it be unclear when the only thing that was at issue at that time was the underlying personal injury action?
I respectfully disagree, Your Honor.
Okay.
Dr. Korn's affidavit identifies that there were multiple cases from which he provided service from which the assignment may attach.
Was the amount identified in the assignment agreement?
Amounts were identified, but Korn's own submissions, Your Honor, in support of his prima facie case, supports the inference that the number was substantially lower than claimed.
Wait a second.
Who signed the assignment agreement?
The underlying personal injury client.
Right. Sacco and Phyllis did not sign it, right?
That's correct.
So what gives you standing to challenge the validity of the assignment agreement?
That we've been sued for conversion.
Right, but so you defend the underlying suit, but you don't challenge an agreement to which you are a non-party, right?
Well, Your Honor, I'm challenging it insofar as conversion of money requires a specifically identifiable fund. To the extent that Sacco and Philos is responsible, that contract does not identify the underlying personal injury case. And Dr. Korn's own submissions indicate that there are potentially more than one action from which that assignment was intended to apply.
So you're saying that the agreement doesn't unambiguously state that the plaintiff, in this case, that Dr. Horn was entitled to $53,300. Is that what you're saying?
That's right, because the issue of which case applies to that assignment is blank.
Okay, counsel, I have a question. So you're opposing the summary judgment motion, correct?
Yes.
So do you have an affidavit from either the underlying personal injury plaintiff or her husband to support or raise a factual issue with respect to what you're arguing? Because as the presiding justice says, you weren't involved in the assignment situation, so you really don't have any personal knowledge. But the two people that were involved are the underlying plaintiff and her husband, who, according to the record here, the husband is the one who put in the numbers, right? So do you have an affidavit from them?
I don't, and respectfully, I don't need it for this reason. If I may be heard.
But you're challenging the assignment, counsel. So if you're challenging the assignment, the only person that has personal knowledge is the two individuals, correct?
And Dr. Korn, who's insufficient to meet his burden.
But counsel, assuming that he made his prima facie, you have to raise a factual issue, correct?
If he meets his prima facie, that's correct.
Assuming he made his prima facie, what have you in there that you have personal knowledge to raise a factual issue?
None, based on the record.
Thank you. Thank you.
Thank you. Your time has elapsed. Let me hear from the plaintiff in this case.
Your Honor, members of the court, good morning. Andrew Solomon for Dr. Korn. I just want to review a little bit about what happened. Well, Sacco and Phyllis did everything that they could to discourage and to frustrate Dr. Korn from enforcing this assignment agreement. They violated the PC order. They violated. They moved to vacate the note of issue. They moved to disqualify Dr. Korn's counsel. They moved for sanctions against Dr. Korn's counsel. And they moved for summary judgment based on an attorney's affirmation, which attached hundreds of pages of medical records that were unauthenticated. But but what really shocked the conscience was after the court issued summary judgment, Sacco and Phyllis made 3 successive motions to stay enforcement, even though they had a statutory right to an automatic stay. All they had to do was post a bond, which they ultimately did to stay enforcement. Yet they moved the appellate division for a discretionary stay of enforcement, When they lost there, they went back down to Justice Crane and moved for a stay of enforcement. And then when they lost there,
He went back for a second time.
3 times. Then they went back to the appellate division a third time.
Did they tell the trial, the motion judge that Justice Gessmer had denied the stay?
They did not say it in oral argument. It was buried at the end of their papers, and it was in order to show cause. And Justice Crane was unhappy about the fact and expressed dissatisfaction with the fact that they didn't come out and say, look, we had already gone to the appellate division and lost this. Yet they went 3 times. And that was too much for Justice Crane, who and she issued a sanction against them. And now on appeal, they raised 2 issues that they didn't raise below that they could have raised below. And one of them, this business about the assignment and whether we had met our prima facie burden. Everybody who was involved in the transaction admitted that the assignment covered the personal injury lawsuit. Dr. Korn's affidavit admits it, and that's at our record, page 150. Mrs. Amendola admitted it in an email where she offered to pay Dr. Korn out of a portion of the proceeds. And Sacco and Phyllis admitted it because they signed an acknowledgement agreeing that the case was subject to Dr. Korn's lien. They signed it the day that they took the case over from Mr. Krantz. So when we were in the court below, nobody raised the issue of whether the assignment covered the personal injury lawsuit, and they certainly didn't dispute it because it was too obvious to dispute. And then this other business about the conversion claim, well, specifically identifiable relates to the funds. And these are specifically identifiable funds. They were funds that were paid by an insurance company to Sacco and Phyllis. It doesn't relate to the assignment, the underlying instrument, which is a matter of contractual interpretation. And if Sacco and Phyllis believed that it was ambiguous, they needed to say that to Justice Crane, and then we would have put in...
Counsel, this is Judge Owing.
Yes,
was it you that said in your papers, in your briefs, that what happens here is because the appellant dispersed the settlement funds, which I think is about $250,000, dispersed the settlement funds, and they retained their portion of their percentage that they're entitled to. By paying you, they essentially then be working for nothing, correct? I mean, is that, did you say that or somebody said that, right?
The fact of the matter is they over-leveraged the case because after they took over the case from Mr. Krantz, they took Mrs. Amendola to 2 financing companies.
Right.
And didn't tell the financing company about Dr. Korn's lien or Mr. Krantz's lien.
Right.
So, there wasn't enough money, so they paid themselves, they paid Mrs. Amendola, and they paid their financing company, but they didn't pay Mr. Krantz. Right. And they didn't pay Dr. Korn, and that was so sue me. And because they're a lawyer representing themselves, they were able to torture us. And we're here.
Okay. Thank you, counsel.
Thank you.
Appellant, you get 1 minute rebuttal.
Thank you, Your Honor. What Mr. Solomon has described is not in the record because no depositions were taken. The reality is this: the contract is blank. If the contract is blank, they can't meet their burden. Relying on predecessor attorneys' letters, which are hearsay and weren't authenticated, is inadmissible. Whether Dr. Korn may ultimately be successful at the conclusion of discovery, had it been conducted properly, is a different story. They didn't meet their burden. Just because Dr. Korn says it so doesn't make it so, particularly when the signing document is blank. If the court has no further questions, I'm sorry.
Yeah, well, my question is, do you have anything to say with respect to what the trial court found was frivolous on your part, conduct that was frivolous?
The only thing I'll address in that regard, Your Honor, was that it was a young attorney who was, I think, genuinely doing his best. And I don't think that there's any mens rea there. Could he have done things better? There's no question, Your Honor, that he could have done things better. But I don't think he acted willfully or in any way contumacious, and I hope that the record bears that out.
Okay, thank you so much. Thank you both.
Thank you.
Callahan versus Haji and UberTech.
Yes, good morning, Your Honors. Scott Horn, counsel representing the appellant in this matter. It's our contention, Your Honors, that the motion court erred in this case in awarding summary judgment to the defendants because their motion was patently premature under the circumstances. In fact, this is the second instance of dispositive motion practice filed by the defendants, but it was filed before any discovery had taken place, before any depositions had been conducted. And
Is there, Mr. Horn, is there any question that this was a hit in the rear accident for which there's presumptive liability?
There's no question that this was an incident where my client was in an Uber as a rear seat passenger, and that vehicle was hit in the rear. That is correct, Your Honor.
And counsel, this is Judge Scarpula, and your client knows everything that happens, correct?
Well, no.
She herself has all the information about how the accident occurred and what happened. There's nothing she knows. There's nothing no deposition is going to help you because she has all the information about how the accident occurred. She was there, and there's no dispute about how the accident occurred. It was a rear end hit.
Well, Your Honor, I would respectfully disagree with regard to the knowledge possessed by a rear seat passenger in a livery vehicle. I would respectfully submit, Your Honor, that the drivers of the two vehicles have a far superior knowledge as to all the circumstances attendant to the accident than does a rear seat passenger in a livery vehicle. If we check our law school degrees at the door and apply common sense, we know that an individual that's sitting in the back of a livery car is more often reading something or looking at their phone, certainly not paying attention with the same level of...
Your client put in a detailed affidavit. She didn't say, I have no idea what went on. She actually said what went on. So that argument that she had no idea is specifically discredited by your client's own affidavit.
I'm sorry, I didn't mean to represent that she had no idea what was going on.
What happened? She put in an affidavit and it said exactly what she saw and what happened. It was a rear end hit. She admitted it. She put in an affidavit about it. There's no discovery that's going to add to that. And, well, and the driver doesn't dispute that. And the other defendant doesn't dispute that.
Well, respectfully, Your Honor, that when you refer to the other defendant, we have to keep in mind that the other driver in this two-vehicle accident has never provided a sworn statement at all. So to the extent that we look at the plaintiff's affidavit, which does say that the defendant Uber driver was driving erratic, was speeding, was applying the brakes aggressively, and that it was raining at that time, yes, I agree that there are two divergent versions of this accident. The third party, the tiebreaker, if you were, would be the driver of the other vehicle, Vern.
Let me ask you this, counsel. What's the difference between what has it got to do with a rear end collision, whether it was raining or not? A rear end collision happened. Everyone agrees about it. And
that's
so
correct.
If it was raining or not raining isn't material to whether or not it was a rear end collision, correct?
Well, no, Your Honor, because I think that if the other driver comes forward with a statement that says the Uber driver, let's speak hypothetically here because we don't know, a statement's never been given. The Uber driver cut in front of him, immediately applied the brakes, and that car says, well, it was wet, the roadway was wet, so I skidded into the back of the Uber driver.
So you're saying that a southern stop defense?
I'm saying that's potential. What I'm emphasizing here.
Did that person put in an affidavit in opposition to the motion for summary judgment?
No, and that's my point. So that's another defendant.
If that person would have put in an affidavit, if you got an affidavit from that person, that might have been a different situation. But that didn't happen.
But Your Honor, I'm sorry, Your Honor. They're a defendant. They're not going to give me a sworn statement. They're going to give me a deposition.
But
and
counsel,
that's exactly, yes, Your Honor.
So this is Judge Owen. But if
yes.
I recall your client's affidavit, the whole swerving and driving erratically, that happened prior to him getting rear-ended. Your client didn't link the driving erratically to the rear end. Unless I'm reading a wrong affidavit, it seemed like he was driving erratically, and then somehow for that brief second, he wasn't driving erratically. Just based on what your client was saying in her affidavit, then he got rear-ended. So there's sort of, just relying only on your client's affidavit, there's a disconnect there. It wasn't that the erratic driving could raise an issue of fact as to whether or not the defendant driver that in which the car she was in was the cause, or at least was comparatively at fault. to causing this rear end, just based on my reading, unless I'm reading a totally different affidavit, which is possible. Her facts don't link up. Her facts don't link up to the rear end. To what you're saying.
I'll give you 30 seconds, Mr. Horn.
Okay. Thank you, Judge. So, Justice Owing, I agree with you insofar as what your characterization is of the affidavit, and in fact, you are reading the correct affidavit.
Thank you, because if we had 23 cases, I don't know. Sometimes I could be mixing up these affidavits.
It's perfectly understandable. I get it. But what I would counter is by saying that she didn't testify that the erratic driving had stopped. That's number one. Number two, we're supposed to look at this affidavit in the light most favorable to the plaintiff. She's the non-moving party. This is all she was able to offer because there has been no discovery or depositions in this case. And so, Your Honors, respectfully, even if you get past the prematurity issue, which I think is pretty clear, viewing the evidence in the light most favorable to the plaintiff, there should be depositions conducted of the drivers before determinations are made as a matter of law. Thank you.
Thank you, Mr. Horn. Let me hear from Callahan. Who goes first? Haji?
I believe so, Your Honor. Good morning, Your Honors. My name is Jonas Weig, appellate counsel for defendant respondents defendant respondents Haji. As the court correctly noted, the affidavit submitted by plaintiff specifically noted that she had information concerning the alleged manner in which the defendant was driving. However, she was unable to submit any evidence concerning the actual events of the accident. Her discussions as to the potential erratic nature.
Do you want to address Mr. Horn's concern with the prematurity of the motion? I mean, they haven't done discovery, so they want to get an opportunity
Your Honor,
to raise issues in opposition to your prima facie case.
Of course, Your Honor. This court has made very clear in repeated holdings that the mere hope of discovering evidence over the span of discovery is insufficient to raise a prematurity argument to defeat a motion for summary judgment. This court has repeatedly held that summary judgment is not premature where the non-movement has control and possesses knowledge of the accident. She displayed by virtue of her affidavit that she was aware of the events occurring over the span of this trip. There's been no case law or any representation of fact by plaintiff that she had no information and was unable to obtain any information as to the happening of the accident. The fact that other parties may also have knowledge of how the accident occurred does not change the fact that she herself, by virtue of being in the vehicles involved, has knowledge and information as to how the accidents occurred. If she were able to, she would be able to testify as to the potential speed or whether or not the vehicles were moving. And indeed, she did in her affidavit insist that the Haji vehicle was moving, but provided no additional information. These attempts to claim that the motion was premature are simple.
Is it material? I know Justice Carpula raised the issue of materiality with respect to whether the vehicle was moving or whether the vehicle, I mean, if we have wet pavement and, or let's use Mr. Horn's southern stop. I don't want to call them allegations because they don't have a basis for it, but hypothetical about whether the vehicle suddenly stopped.
Preliminarily, Your Honor, it should be noted that all of these are solely hypotheticals. There's no evidence in the record to support them. Moreover, even if they were true, those facts alone would still not be enough to prevent summary judgment. This court has held that a claim of a sudden stop alone is insufficient to prevent summary judgment. This court has also held in Sosa versus Remat that even in an instance where the vehicles are still moving and the lead vehicle has not stopped, without additional information from the non-movement explaining how there is some negligent action by the lead car, summary judgment is still appropriate. And so the facts submitted by the plaintiff in her affidavit are completely immaterial. None of them point to the actual happening of the accident. None of them point to any negligence by defendant Haji. And there is no basis or situation that the plaintiff submits why she is not in control of sufficient facts to be able to present them at this point. And as a result of that, the motion is neither premature, nor has the prima facie case been sufficiently opposed, and summary judgment was appropriately awarded. And if there are no further questions, I'll rest on the brief.
Thank you, Mrs. White. Ms. Braun?
Yes, Your Honor. May it please the court, Julia Braun for the defendant respondent, Uber Technologies, Inc. I will rely on my brother counsel's arguments and his brief as they were so cogently worded and stated. I would just add that because plaintiff appellant could not prove negligence as against the defendant respondent, the court need not reach any vicarious liability arguments. And in fact, those were not in the record before this court. And that is the basis that was claimed as against Uber Technologies, is that they were vicariously liable for the acts of the defendant respondent driver. However, that's not before this court at this particular juncture. And we would just simply state that because the plaintiff appellant could not reach his prima facie case, that he should the issue of negligence against the driver should not be reached as to Uber.
Okay, thank you. Questions, panel? We're good? Thank you, Ms. Braun.
Thank you.
Okay, we get 2 minutes for Mr. Horn in rebuttal.
Yes, thank you, Your Honor. Very quickly, I would like to point out, if we move beyond the prematurity argument, which I think is very straightforward and self-evident, the facts underlying prematurity are really undisputed here. When you move beyond that and you look into the competing affidavits, I think one thing that we need to focus upon is the manner in which defendant Haji met his prima facie burden. And that was by submitting an affidavit which clearly and unequivocally said that his vehicle was stopped in heavy traffic for about 4 minutes. And it's based upon that singular showing in an affidavit that his prima facie case is based. In opposition, the plaintiff submitted an affidavit which unequivocally stated that the Uber vehicle was moving at the time of the act.
But the question is whether that's sufficient, Mr. Horn. If the vehicle was moving, although that in a rear end collision, what it means is that the car behind should apply more distance between the two vehicles. In a rear end collision, that doesn't relieve your the driver of responsibility.
Well, it establishes a triable issue of fact on the factual basis for their prima facie case. But moving beyond that, Your Honor, your point is exactly correct. And that circles back to the concept that we've never received the sworn statement from the second driver, the driver which could presumably bear the greater culpability in this case. There's never been a sworn statement, let alone a deposition from that driver. That is not within the power of my client to get a statement from that driver. It's an adversary party. That's a party that needs to be deposed. And so when we look at the circumstances here, the affidavit submitted by Haji, the affidavit submitted by my client, a rear seat passenger, which specifically says the vehicle was moving, thereby creating a triable issue of fact on the very basis for the defendant's prima facie burden, we submit again, Your Honor, that depositions need to be conducted here before any determinations are made as a matter of law.
Thank you,
Counsel,
Mr.
let me just say that the finding of liability doesn't rest on stop vehicle. It rests on rear end collision, and there are 1,000 cases on this issue: rear end collision, regardless of stop vehicle or moving vehicle. Rear end collision means one thing, and that's what the basis of liability is on. I just want to.
I'll give you 20 seconds to answer that, Mr. Horn.
Thank you very much, Ron. I appreciate that. So I agree what you're saying. I agree with what you're saying, Justice Scarpula. The only point that I would make is that the rebuttable presumption arises as a consequence of the stopping or the being stopped. And that was exactly what the defendant relied upon in moving for summary judgment. And that dispositive factor in that rebuttable presumption, in that prima facie showing, was countered by the plaintiff.
Thank you. Thank you so much to all three of you.
Thank you, Your Honors.
A more lively argument than I anticipated in this case. KBS. Okay. Let me first hear for counsel for Terrapin.
Your Honor, this is Ashley Miller on behalf of counsel for Bank of New York. Terrapin is actually not the appellant. Bank of New York is. Terrapin,
right.
Yeah, Terrapin did not submit any briefing in this appeal.
Got you.
Um,
Go ahead.
All right. Good morning, Your Honors, and may it please the court. I'm Ashley Miller on behalf of Appellant Bank of New York. The respondent in this matter, KBS Sheepshead Bay, tries to bog the court down with a bunch of facts about the long history of the various foreclosures in this matter. But really, there's a simple issue. And the issue is, what effect did my client's EMA have? And how did that affect the prior mortgage with BR2 Realty, the mortgage that's called the substitute mortgage number 1. And the case law and the mortgage documents all make clear that that mortgage was given in substitute for substitute mortgage number 1. And the judgment
Counsel, this is Judge Owing. What took your client so long to prosecute their case? I mean, we're talking, first of all, your mortgage isn't extinguished. You're just now number 2 instead of number 1, right? I mean, that is clear, right?
No, Your Honor.
Your mortgage is gone, or you still have just number 2? You're not priority anymore.
No, Your Honor. Our argument is that we are priority.
I understand.
Our mortgage was never extinguished.
I understand that. I'm just saying right now, what we have is that you're number 2. You're not number 1.
Per the Supreme Court's holding.
Yes,
right.
Exactly.
I mean, it's Supreme Court's holding is really that it was your failure, your unreasonable delays and failures that led to KBS taking over a note and a mortgage with what does she call it, with reasonable understanding that your interests had in fact been discharged.
I understand that, Your Honor, but that history really doesn't matter in light of the fact that our mortgage was never canceled. If you look at the documents, our mortgage, the EMA, was the mortgage, the mortgage that superseded the mortgage that was canceled. And KBS admits that the judgment on which it relies to say that a prior mortgage was canceled, to claim that it took a first mortgage position, that judgment never mentions our EMA, and the EMA is what controls here. The EMA is the operative document. So
well,
there's
I have
never
a question, counsel. When you say the EMA is the operative document and controls, was that EMA ever filed anywhere, recorded anywhere?
Yes, Your Honor. Yes, it was recorded in 2007. Again, KBS, no one's ever disputed that the EMA is recorded. It was recorded in 2007. It's been recorded against the property since 2007.
But the EMA, I mean, the EMA is not a new lien, right?
Yes, it is, Your Honor.
It's independent from the 2007 mortgage, right?
It is, Your Honor. It is a completely new lien. Again, and the terminology is important here because there's reference to the 2007 mortgage, and I think that's confusing because the EMA and the substitute mortgage number 1 were executed on the same day. The whole purpose of this transaction was, like any SEMA transaction, to try to save on mortgage recording tax.
So the amended cancellation order, which was in effect at that time, right? So how did that alert KBS when he was doing his due diligence in January and February of 2015?
That judgment only refers to the substitute mortgage number 1. And that doesn't say anything about the EMA. It doesn't talk about the EMA at all.
So it doesn't appear to discharge the EMA, right?
It does not appear to discharge the EMA, and KBS admits that. KBS admits it doesn't discharge the EMA. But so the question is, what effect does the EMA have? And this court has held that that the language in the EMA, this court has considered multiple times, held that the language in the EMA and the consolidated note. Again, there's another issue. The RAS executed a whole new note, a consolidated note that is secured by the EMA. This is a whole new loan, and this court repeatedly, and also the Court of Appeals in Citibank versus Plotch, has considered this issue and has held that when there's the same language as appears here, that the EMA and the note take priority and are substituted for any prior mortgage. And so the fact that the judgment never canceled them should have put KBS on notice that this EMA was still a record. So
let me ask, counsel, let me ask you a question. When you sought to foreclose, what did you foreclose on?
We foreclosed the EMA. And
you foreclosed on the EMA and not the 2007 mortgage?
No, Your Honor. We're foreclosed because yes, the complaint.
Be careful what you say. I got a record in front of me.
Your Honor, let me explain. The complaint makes reference to the substitute mortgage, no question. But you know why? Because there's a reliance on that mortgage only for the purposes of recording tax. If you look at KBS,
I'll let Justice Garcia ask the question because she's looking like she wants to ask you a question.
If you look at KBS's complaint,
someone's entitled to look at what you plead and not the underneath what you subjectively think about it. The documents were the same, the amount was the same, you pled it. So how could a reasonable person looking at all that information not believe that they were going to have a first mortgage? Not because of your undisclosed belief that you wanted to avoid mortgage taxes. They see what you plead and what happens.
Your Honor, we didn't plead it. The complaint says we are foreclosing the mortgage.
Let me just ask you this, counsel. Was the lender the same?
No.
No?
No.
Was the principal amount the same?
The only similarity between the two loans is the principal amount.
And the underlying mortgage property, correct?
No. The underlying mortgage property is different. The substitute mortgage note number 1 is actually recorded against all 3 condo units. The EMA is recorded only against unit number 1. Our foreclosure complaint says
so the EMA is the same, even though it's a subset, but the property is the same. It's not all the property, but it's the same property.
The foreclosure complaint says it is foreclosed, Your Honor. Yes, but the note, which is again the operative document we really care about, is the note. The only note attached to the foreclosure complaint is the consolidated note, the note that we are saying takes priority. The substitute mortgage number 1 is not attached to the foreclosure complaint at all, and the complaint says the loan that we are foreclosing is the loan that is represented by the consolidated note, the note that's attached to Exhibit A, which is the consolidated note. That note is secured by the EMA. There's no one disputes that. So the loan that's being foreclosed is the note that's in the consolidated note, and that note is secured by the EMA. So the only similarity.
Let me ask you this: what did you seek to foreclose upon?
The EMA.
But you also sought to foreclose on the 2007 mortgage, correct?
Again, the 2007.
To answer my question. I definitely want to hear what you have to say, but I just want you to answer my question. Did you not also foreclose on the 2007 mortgage?
It's not black and white like that, Your Honor.
I think, the documents say what they say. So you tell me, what does the document say?
So yes, there is a reference to the substitute mortgage, but if you look
reference in the foreclosure complaint, right?
If you look at KBS's complaint,
counsel, I just want you to answer, and then I promise I'll hear what you have to say.
Okay, I'm sorry. Say that one more time.
Did you put that 2007 mortgage in the foreclosure complaint?
It is attached to the complaint, okay. Yes, Your Honor. All right.
So you saw the EMA not only on the EMA but also on the mortgage.
The EMA is
mortgage.
The EMA is also attached to the complaint. But you know what, Your Honor? If you look at KBS's mortgage is also a CEMA, and if you look at their foreclosure complaint, they refer to the the mortgage of the prior lender that was then consolidated with their mortgage. You have to do that because there is a basis on which to go back. But if you ask KBS, they're going to argue that the operative document for their mortgage is their SEMA. This KBS's mortgage. The fact that they went.
Well, that's a good. You run way over your time. You've got 9 minutes, Ms. Miller. It's a perfect entry into hearing from cross appellant KBS. Mr. Berman?
He's muted.
You're muted.
My apologies, Your Honor. I should know a little bit more about technology. Mark Berman, counsel for the respondent, representing KBS, both on the affirmance of Justice Bluth's summary judgment motion and in opposition to Bank of New York seeking reversal of the summary judgment in their favor, and on the cross appeal. Your Honor, Justice Bluth got it right. She granted summary judgment on laches and the bona fide nature of the lender. When you look at Bank of New York,
how do you respond to appellant's argument that there are two separate documents we're dealing with, and the EMA is the one that still survived, and that wasn't touched. So therefore, based on that, they still maintain priority over you.
Okay, let's start with the fact. Let's go to what Judge Scarpula indicated. Number one, their complaint, their own pleading, says they're foreclosing on the 2007 mortgage. After this whole mess comes about, they amend their foreclosure complaint. And what do? Specifically, they sue on the 2007 mortgage, not the EMA. Now,
what does that indicate? That, in fact, the EMA is not a new lien. It's not independent from the 2007 mortgage.
That's correct, Your Honor. It's not independent. And we heard counsel say it's all about the note, the consolidated note. It's the mortgage upon which a lien is created. Now, she cited case law. This is not a SEMA. All appellants' cases are SEMA cases. Why are they SEMA cases? Because new money is added. If new money was added in this transaction, and as Judge Scarpula noted, no new money was added, zero, this would be a different story. But this is an EMA case, and the Court of Appeals has very, very clearly said when there's no new money added, and this is the District Court affirmed by the Second Circuit, and this law still governs applying New York law. A consolidation agreement combining multiple outstanding mortgages into a single lien is not considered a new mortgage when there is no money added. The Court of Appeals, in affirming, said a consolidated mortgage does not represent an encumbrance independent of the prior. So we're talking not about an EMA. They didn't foreclose on an EMA. They didn't amend to foreclose on an EMA. If it was the EMA that governed, the Bank of New York, in their discharge, seeking to oppose the discharge, they wouldn't have done it. Why? Because according to them, the 2007 mortgage was an irrelevancy. But they did go to discharge that. Why? Because they all knew it's all about the underlying debt. If you look at the record and you look at the EMA, the word consolidation was crossed out. This is not about a consolidated note. This is not about a consolidated mortgage.
The amended cancellation order is what was in effect when you did your due diligence back in January and February of 2015, correct?
That's correct, and it was on public record for about 8 months. And interestingly enough, even before we closed in February 2015, the discovery shows the Bank of New York knew there were issues, and this goes to what Justice Owing said at the beginning of the oral argument, what did they do? What took them so long? This is what Justice Bluth said. They knew there was an issue, and the sine qua non, the key to laches, is legal prejudice. This is a 2008 case that had been dismissed of record since 2012. what does someone look at? Where's the notice of pendency? We all know, you all know what the effect of a notice of pendency is. In their moving brief and the reply brief, you won't even see the mention of a notice of pendency. Why? A notice of pendency is what puts everyone on notice. The notice of pendency had expired. So at the time of the transaction, there was no operative notice of pendency. There was a cancellation order. There was an amended cancellation order. There was a complaint that counsel is just wrong when she says that the complaint did not seek to foreclose on the 2007 mortgage. They looked at what they should, and there is very important, because many of you were trial court judges, Your Honor, there is not a single affidavit by the Bank of New York as to laches, as to the bona fide nature. They cannot oppose in any way the prima facie case we have put on the basis of laches and the bona fide nature. The deposition testimony says very clearly, they didn't miss the EMA. When no new money is added, they looked appropriately at the 2007 mortgage, and that deals with amendments and extensions and modifications. There was, Judge Scarpula, Justice Acosta, no consolidation here. That is a sleight of hand. And we know it's a sleight of hand because after all this is done and they sought to amend their foreclosure complaint, did they seek to foreclose on the EMA? The pleadings speak for themselves. They did not. So with that, Your Honor, we have no opposition to laches. There is no affidavit whatsoever. This is 2020. This is a 2008 case. There is no excuse. They moved for summary judgment. They withdrew it. They moved to vacate. It got denied. Everything was quiet. They did nothing. And the only thing they did was after my client lent money. What else could a bona fide lender do? They have no facts, no affidavit, no case law that supports the bank should have done a single thing else. With that, Your Honors, I rest on appellant's argument and seek affirmance of Justice Lutz's decision below.
Thank you, Mr. Berman. Ms. Miller, you get 2 minutes rebuttal.
To address Mr. Berman's first argument, which was that we have no new money for the EMA, the mortgage that he refers to as the 2007 mortgage, which we call substitute mortgage number 1, because that's what the documents call, there was no new money for that mortgage either. Mr. Rath, as a member of Terrapin, includes an affidavit on the end of that mortgage saying that there was no new money for that. The money that was lent, that $2.7 million, was lent in part at least a year before, and perhaps even many years before, because all that money was chunked off of a much larger $13 million mortgage.
Ms. Miller, can you address yourself to the laches argument? I mean, surprising. I don't want to repeat what Mr. Berman said about the lack of factual dispute about the delay and whether they basically had a reasonable understanding that your interests have been in fact discharged.
Your Honor, they didn't have a reasonable understanding, because if you read the EMA documents and the documents that originated our loan, those documents are clear that the EMA supersedes. Their laches argument is really irrelevant, because for the entire time our EMA has been of record. There's no dispute about that. So for the entire time, so the fact that they are trying to, again, bog the court down in this whole history of the foreclosure is really irrelevant. But still,
Did you notice
there were a lot of sorry.
Counsel, did your notice of pendency expire though?
It did expire at one point, Your Honor. Yes, it did expire at one time. Right. But that doesn't really matter, because the email was still of record. Oh. I would also add that there were several red flags when KBS took out its loan that they should have looked into. For example, the quiet title action, as this court held, was improper. It was brought by an entity that no longer had any interest in the mortgage, the note, or the property. no longer had any interest in the loan. This court held that. And these are things that a red flag that KBS should have looked into more. They should have looked into
Counsel,
what
I have
the
a question.
judgment did.
Counsel, the
Yes.
red flag for me to you is that when your notice of pendency expired in 2014, are you claiming you didn't get notice that your client didn't know that the notice of pendency expired?
Your Honor, before that,
Well, no, it's either yes or no. I mean, did your client know that their notice of pendency expired? Because, okay, you're saying that that's irrelevant. I don't think so. That's a record. That's a record document that sets the world on notice that there's a lien on your property. If that expired, are you telling me your client didn't know that that happened?
Your Honor, we couldn't file a notice of pendency because the foreclosure action had improperly and voidly marked disposed, and there were efforts being made to restore it. But because there was no pending for,
Okay.
I mean,
Okay.
there's no pending foreclosure action to file a notice of pendency. And also, one more point: our foreclosure action is not
I'll give you 10 seconds. You already got 3 minutes.
Our foreclosure action is not foreclosing the 2007 subordinate substitute mortgage because the note is not attached to the complaint. That the note for that mortgage is not attached to the complaint, so we cannot be foreclosing it. Thank you.
Thank you, Ms. Miller.
Thank you, Your Honors.
You exhausted your 2-minute rebuttal, Mr. Berman?
Well, if I could have 30 seconds, Your Honor.
You have a cross appeal.
I do, Your Honor. Let's just, a couple issues I want to raise. Ms. Miller talked about red flags. There is no affidavits or any factual support for red flags. She started her argument concerning the prior loan, 2006, and that didn't add new money. Remarkable to rely upon that. That loan was never assigned to the Bank of New York. So if you follow her logic, and that's the operative document, her foreclosure action, again, sought to foreclose on the wrong mortgage. Lastly, she talked about the word, this superseded. If you look at the Court of Appeals decision, the Court of Appeals decision that was affirmed by the Second Circuit used the same language, superseded, and it didn't make a difference, effectively restated, and there was no money. With that, Your Honors, I rest and I seek affirmance of Justice Bluth's decision. Thank you very much, and happy Thanksgiving.
Thank you, Mr. Berman. Thank you, Ms. Miller.
Happy Thanksgiving.
Happy Thanksgiving. Gottwald versus Sieber.
Thank you, Your Honor. This is Anton Medlitsky from Ms. Siebert. Would you like me to start now, or would you like Mr. Movid to move in his colleague first?
Have him move his colleague in, just so that we have everybody in the ball field.
Good morning, Your Honors. My name is Jeffrey Movitt. I am New York counsel for respondents. I respectfully request that the court allow my law partner, David Steinberg, who has been admitted pro hoc vice for this appeal, to argue on behalf of respondents.
Good morning, Your Honors.
That application has been previously granted, Mr. Movitt. Thank you.
Thank you, Your Honors.
Okay, let me hear from Appellate.
Thank you, Your Honor. May it please the court, Anton Medlitsky for Ms. Siebert. My time is limited, so I'd like to focus, if I could, on 3 issues: public figure, litigation privilege, and the duty of good faith and fair dealing. Starting with public figure, imagine a newspaper lead that read, Dr. Luke, music producer who gained fame and fortune by cultivating his image as someone who turns young female artists into pop stars, was accused by one of those young female artists of rape. Established First Amendment precedent would not allow such a well-known person to prevail in a defamation claim against the newspaper without showing actual malice by clear and convincing evidence. But the trial court's decision would, which is why so many major media organizations have appeared as amici, urging the court to reverse it.
So help me with that, counsel, because, just with respect to being a public figure, is Dr. Luke so, let's just cite Gertz, right? So has he achieved such pervasive fame or notoriety for all purposes?
Well, we think the answer to that is, we think the answer to that is yes, for the same reason that the Winklevoss twins were. But I don't think you have to get there, because at the end of the day, the James line of cases, James, Mall, Park, most recently, this court's decision in Winklevoss hold that a defamation plaintiff is a public figure if he has taken affirmative steps to attract personal attention or strive to achieve a measure of personal claim. That's a quote from Wall.
But in the Winklevoss case, I mean, you were talking about plaintiffs who were general purpose figures because they were famous by basically having participated in the Olympics. That's sort of right. World event, world related fame, right? That's not fame or notoriety within a particular industry, as in this case.
So again, I think they were Olympic rowers. I'm not sure how actually famous they were. He is a celebrity music producer. He was awarded a star on the Hollywood Walk of Fame. He was chosen to be an American Idol judge. He's been written up from the New Yorker to Rolling Stone to Billboard magazine, et cetera, et cetera. But again, you don't have to.
Let me just say this to you. You're saying that he's at least as Dr. Luke is at least as famous as two Olympic rowers, correct?
At least as famous as two Olympic rowers.
More, right? Maybe some people in baby boomers might not know him as well as our children, but our children certainly know him more so than any Olympic rower.
That's exactly right, Your Honor. And equally important, just as the Winklevosses were also limited public figures because they sought publicity in the area of business relations, and that's the area in which the defamatory statements were made. Certainly, Dr. Luke sought publicity in the area of being a movie producer and especially making young female artists stars and his relationship with them. I mean, he's obviously more famous than the Buffalo belly dancer in James or the doctor in Park, but they were public figures for purposes of statements made within the sphere in which they got famous, and so is he. And so it seems to me that it's pretty obvious under this court's long line of this court's and Court of Appeals precedent that he's a public figure, at least for purposes of the statements here. That is, that he sexually assaulted his client, one of the clients for which he got famous. Now, on the litigation privilege, as the court knows,
before we go there, so what are the elements of? I mean, if he's I thought that one of the elements of being a limited public figure has to do with an intentional or some intent on his part to inject himself into the actual controversy, right? Rather than being dragged in by allegations.
No, so the essential, I mean, I'm quoting from the Court of Appeals here in James, the essential element underlying the category of public figures is that the publicized person has taken an affirmative step to attract public attention. The court also held in James that although such persons have not necessarily taken an active part in debates on public issues, they remain nevertheless persons in whom the public has continued interest. So the question is, has he attracted attention to himself? The answer clearly is yes. He's hired 4 PR firms. He's voluntarily participated in all these, glossy articles in all these different magazines. He's much more famous.
So you think that the glossy articles and his intent in seeking attention means that he thrust himself in the vortex of the public issues or engaged the public attention on the important public matters implicated in the statements.
Yes, I mean, just as in James, as in Park, as in Mall, as in Winklevoss. If the question is, does there have to be a particular public controversy that he spoke on? The answer is no. As I just read, from James, such persons have not necessarily taken an active debates on public issues. If you think the answer is yes, we'd win anyway. But again, you'll search in vain for.
I want to ask you this question. Would you agree with me that New York law on defamation is a little bit more nuanced than Gertz, which is quite old, and that New York law has advanced a little bit further than federal law, particularly the Gertz kind of public figure law?
Yeah, I mean, I'm not exactly sure whether it's right to characterize it as New York law or just courts construing federal law. But Gertz didn't suggest that it was talking about every possible kind of public figure. And again, starting in the 70s with James that Mall in the 80s up to Winklevoss last year, every single one of those cases was just about people who thrust themselves into the limelight. They sought publicity. That's all. That's all that's required, so long as the statements are within the scope of that publicity. And so that's clearly satisfying.
Saying that regardless of the issue, if I seek public fame, you know, if I want to be known as the best judge out there, and I'm seeking publicity, all of a sudden, then any issue, any accusation that is made against me, then I would be considered to be a limited public figure because
no, Your Honor. No. So you can,
because he's not getting, from what I'm reading, he's not inserting himself into the controversy of sexual abuse, rape. He's simply seeking fame as a music producer.
That's right. And so there are two.
How does that, in and of itself, bring him into this controversy with the, let's call it the Me Too movement?
Your Honor, a few points. First of all, some people are general purpose public figures. They are so well known that they are public figures for any kind of allegedly defamatory statements. The Winklevoss twins were that well known, and so is Dr. Luke. But we don't think you have to resolve that question because under New York law or under the New York cases, you don't need a particular public controversy. What you need, again, and I'm just quoting from the case, the essential element underlying the category of public figures is that the publicized person has taken an affirmative step to attract public attention. Such persons have not necessarily taken an active part in debates on public issues. When you're talking about a person like that, they might not be pervasively famous, but like the belly dancer in James, nobody knew her outside her community, but she was a public figure, not because she took a position on some public controversy, but because she made herself famous as a belly dancer. And so statements about, her belly dancing are okay. So statements.
The belly dancing statements, right?
Yeah, and these statements, he has made himself famous, sought publicity about how great of a producer he is of young female artists, how he makes them stars, and how great his relationship with them is. And the allegation here is that he sexually assaulted them.
So taking affirmative steps. So the answer is taking, or your position is that taking affirmative steps for notoriety makes him at least a limited public figure for all issues, including allegations or issues of sexual misconduct, etc.
For issues having to do with where he sought notoriety. I mean, these aren't statements about something having nothing to do with him being a music producer for young stars like Kesha. The allegation is he not only sexually assaulted his own young client that he got famous for representing, but also forced her to stay in her contract after the fact. I mean, it falls squarely within the area in which he got famous. Now, we think if you think there needs to be a public controversy, there is one. We lay it out in the brief, but there doesn't need to be one under James and Mall and Park and Winklevoss. Now, on the litigation privilege, as this court knows, New York recognizes a broad litigation privilege against defamation to protect the public's ability to speak without fear of liability in court proceeding. And the trial court correctly didn't doubt that the 25 statements at issue would be privileged as a general matter. But the court also thought that because there's a dispute of fact about whether Kesha's allegations that Dr. Luke raped her are true, that means there's a dispute about whether Kesha's underlying California litigation, which then turned into her New York counterclaims, fell within the sham exception to the litigation privilege. Now, that analysis is wrong because the privilege applies even if the statements in the underlying litigation are not true. That's the whole point of the privilege.
No, wait a second, counsel. This is Judge Scarpullo. That's not what Judge Spector held. She held that the reason why there was a question was because of the memo that said, we are going to sue this guy in California to destroy him. That's what she said raised the issue of fact, not the fact of the lawsuit.
Well, Your Honor,
I disagree with that. I mean, that's clear. That raises an issue as to whether or not this is a sham litigation.
Your Honor, I don't think it does, because the question whether something is a sham litigation is not about whether the statements are true or even the motive. I'm reading from this court's decision in Sexter and Warnflash. It's 38 AD 3rd, 163. An offending statement pertinent to the proceeding in which it was made is absolutely privileged, regardless of malice, bad faith, recklessness, or lack of due care, and regardless of its truth or falsity. There is a sham exception, but the sham exception is about whether the litigation is real litigation. That is, whether it was actually prosecuted, right? So every single sham case, Halpern, Lomenham, Thomas.
Okay, so she dropped her litigation in
She
California.
did not, Your Honor.
Right?
So what happened?
Continued it.
Well, no, what happened in this case was she brought a California, right? So when it was stayed, she tried to get it unstayed. Then she just filed the same claim here. And in cases, at least 2 cases in this court, Latcher and Manhattan Sports Restaurants of America, held that when a party actually proceeds through a motion to dismiss, which is what happened in this case, it cannot be a sham as a matter of law. Not only that, a sham litigation is only a litigation where there aren't any facts to back up the allegations. Here, they didn't even move for summary judgment on the underlying facts. We're going to trial. It can't possibly be.
They move for summary judgment, and I'll give you 30 seconds to address this. They did move for summary judgment on the text that Keisha sent to Lady Gaga, right?
Right, but that's not one of the litigation. That's not one of the litigation privilege allegations. Now, we think that should be out for a different reason, which is all that text was a recount of a conversation that those 2 people had with a third party. I mean, the only reason anybody in the whole world knows about that text is because Dr. Luke put it into a complaint, but that doesn't have anything to do with the litigation privilege. Now, if I can have...
It's a statement it's a statement in the text about an underlying matter, one which is not true and has been vehemently denied by the subject of the alleged sexual misconduct, right?
Right, but there was no new publication because all it was is Kesha and Lady Gaga had a conversation with a third person. That third person told the 2 of them that Dr. Luke raped Katy Perry, and then they texted.
So it wasn't Kesha telling Lady Gaga. There was a third person involved.
No, the Lady Gaga and Katy Perry both spoke to this other third person who told them this fact. In any event, that's not about the litigation privilege. And the one point on the duty of good faith fair dealing, just 10 seconds, is simply that there's a black letter law rule. If you don't move for summary judgment, you can't get summary judgment. And the trial court granted summary judgment on our affirmative defense, and that should be reversed for that reason.
Thank you, Mr. Metilsky. Let me hear from Mr. Movitt. I'm sorry. Do we hear from Prohavici?
Yes, Your Honor. Thank you, David Steinberg, on behalf of plaintiffs and respondents. First of all, I'd like to thank the court and opposing counsel for allowing me to pinch hit at the last minute for Ms. LaPera, who had a family emergency. Turning right to the public figure issue, I think there's a conflation of issues that have gone on here. You're either an all-purpose public figure or you're a limited-purpose public figure. That has been made clear by Gertz. There's really no in-between.
So, counsel, this is Judge Owing. You know, I'm listening to the arguments here. There is some case law out there that shouldn't this be a factual issue, do you think?
I'm sorry.
Do you think this is a factual issue that it should be presented as a trial of fact with the dispute going on here? There is cases that sort of lend to that kind of support, though. Don't you agree?
Well, Judge Schechter certainly determined that this was an issue of law for her to decide.
Yeah, but I'm just saying, but just hearing the arguments here and how, you know, we're having so many things going on, swirling around. I mean, all the cases where they found someone is either a public figure or not a public figure, or limited public figure or not a limited public figure. The facts were pretty straightforward, pretty hardcore, down the middle. The court can make an assessment. Here it seems like there's just so many moving parts that maybe at a minimum, it's not a matter of law and it's a matter of fact, right? Because it seems like we're getting more and more complicated because of the era of the age we live in now, in terms of all this activity that's going out there, the Twitter, the Instagram, and all that. There's now become sort of now we're morphing over the decades from Sullivan, Gertz to now, that it may be now time to say it's a factual issue and not a matter of law. Do you think?
Well, Your Honor, I'm not aware of any case law that allows the jury to determine whether someone is a public figure or not. So
I didn't say there was, but there is case law that says that if there's disputes, it should go to a jury or trial of fact. It's when it's undisputed that it's a matter of law. And what I'm suggesting is because of the times that we're living in with the Instagram, your Twitter, God knows, I don't even know how to do all that stuff. But that's all added new factors now that Gertz and Sullivan and all those cases, the old cases that we're talking about, didn't have. So shouldn't it maybe now we're transforming this into a factual issue situation?
I suppose the case law could go in that direction, but I'm not aware of anything that requires that at this point.
Because like Justice Carpula said,
Mr. Steinberg, so let me just frame it. You think the dispute is really not about the underlying factual issues. I mean, it's pretty much clear what took place. The jury is going to have to decide whether who's telling the truth, right?
Of course.
I think Judge Owing is referring to, okay, so what is the standard that we apply? And you seem to have been going in that direction. What is he a general public figure? Is he a limited public figure? What are the elements that comprise both characterizations or both conclusions? So I'll let you answer that.
Thank you, Your Honor. That is correct. The Supreme Court in Gertz did provide the guidance for determining whether someone is an all-purpose public figure or a limited purpose public figure. Judge Schechter, reviewing the record, which is the totality of what is relevant to that determination, concluded that it wasn't even a close call on the all-purpose public figure. She stated that he is certainly not an all-purpose public figure, recognizing that Gertz and its progeny say that it's in the rarest of occasions and very few people attain that.
Counsel, I got to interrupt you. At that point that you just made goes back to what Justice Carpula mentioned, that the baby boomers may not know this individual, your client, but people who are in the know may know your client, so that goes towards the fact of whether or not your client's either a public figure or not. It depends on the makeup of who's sitting there and figuring out, because, you know, that's the whole reality of this, right? It depends on what generation you are.
Well, Your Honor, I think what Judge Schechter did was she looked at the evidence that was presented, and with all due respect to opposing counsel, the evidence that was presented and that was relied upon by defendant really was limited to many articles that just mentioned Mr. Gottwald as someone being behind the scene. He was not the feature of most of the articles, whereas many of his...
Let me ask you this. Does Dr. Luke try and get popular opinion? You know, does he try and put himself out there, or does he not? Doesn't his entire amount of money that he makes in his field depend on how well he is known by people who want to hear his music, listen to his music, listen to the music he produces? He's not hiding himself. He's trying like heck to get himself out into the public, correct? That's his whole deal. He's not, you know, my next door neighbor. His whole deal is to be worldwide known so that his music and his production and everything he does makes him money, correct?
Certainly everything he does is
you're saying that someone like that is a private figure?
Under Gertz, absolutely, Your Honor, and here's why.
I don't know how you could say that, honestly.
Here's why, Your Honor. Mr. Gottwald is a songwriter and a music producer. He is no different than anyone else who is trying to promote his business, trying to become successful.
Elton John, Andrew Lloyd Webber, all those producers and writers, right? He's just like all of those, only he produces music that maybe baby boomers don't listen to, but certainly Gen Xers and people maybe younger than baby boomers are completely and totally into and would know him without a doubt.
Yeah, Mrs. Steinberg, just to follow up on that, I mean, your position is that the general, the question is not whether he has sought to notoriety, but whether he in fact as a result of that notoriety, has become a household name or achieved general pervasive fame and notoriety in the community. That's the standard, right? Can you address yourself directly to that?
Justice Acosta, you are exactly correct, and that is what our United States Supreme Court has dictated is the standard. So whether baby boomers might know him, which I take issue with, because again, if you look at the articles and if you look at the evidence cited, most of it is him. Who is this guy? He's behind the scene. Whereas the artists he worked with may very well be public figures.
Does he have a Walk of Fame? Does he have a star on the Walk of Fame?
Your Honor, he does not. I believe there was a discussion about that, but think about that in and of itself, Justice Oing. There are 2,500 people who have stars on the Hollywood Walk of Fame. Surely nobody is arguing that all 2,500 would be all-purpose public figures under the dictates of the United States Supreme Court and Gertz.
There's a first for everything. I don't know.
I'm sorry, Your
There's
Honor.
a first for everything. I don't know. I mean, I don't know if any of those folks have sued for defamation yet. So
Well, Your Honor, I have walked on the Hollywood Walk of Fame, and you'll see people's names, and nobody's heard of them, but they've had success in their own right.
Yeah, Counsel, Mr. Steinberg, can you can you limit can you address yourself to the limited public figure?
Of course.
Standard, because the way that I read the element or the standard for that is you're required to have thrust yourself into the vortex of the public issues or engage the public's attention on the important issue related to the defamatory statement. Is that still the standard? Mr. Matilsky doesn't seem to think that it is.
Well, until Gertz is overruled by the United States Supreme Court, it absolutely is the standard. The issue here is whether or not Mr. Gottwald ever injected himself into this public controversy, the public controversy being the drugging and sexual assault of women. Now, the fact that Mr. Gottwald had a persona or success and had promoted himself as a songwriter or as a music producer, there is absolutely no evidence whatsoever that he ever injected himself in the controversy or in the public discourse involving sexual assault or drugging of women. And in each of the cases cited by defendants, the defamation plaintiff had discussed the specific issue that was the subject of the defamation, whether it was the belly dancer who gave the interview and that interview then accused her of being a prostitute, or whether it was any of the other.
So that's your argument. If I understand, is that your argument that the California action is actually the timeline that you're looking at? In other words, before the California action, your argument is looking at the California action, because everything after the California action is where the sexual assault thing just blew up and got out and became public, right? But before that, he was just, according to you, a regular manager. I mean, he didn't insert himself. It was the California action that started it.
Your Honor,
you can't bootstrap the post-action, insertion as a way of getting to be limited public figure, right?
You're 100% correct, Your Honor. And two things on that. First, the issue of whether or not Mr. Gottwald was a public figure is established at the time prior to the defamation, which was 2014, which was years before the Me Too movement even started. But more important. Let
me just interrupt you. So you're saying unless Harvey Weinstein actually talked about sexual assault, that he could not be considered a limited purpose public figure as a producer who went out and tried to recruit young women to make them stars, and then when they accused him of sexual assault, that he would be a private citizen in that circumstance?
Your Honor, first of all, Harvey Weinstein may very well have been in all.
I mean, that is exactly that's the analogy that you are saying, because Dr. Luke didn't specifically talk about sexual assault, he can never be considered a limited purpose public figure for the purpose of Kesha's statements about him and what he did in their relationship when he took her in to his group of performers that he was trying to promote.
Your Honor, Gertz, the Supreme Court in Gertz required that.
Yes, we all know what it said.
Your Honor,
I'm asking you in that analogous.
Mr. Steinberg, I'll give you time to answer those questions.
Thank you, Your Honor. Your Honor.
No, after Judge Scarpula finishes, she can speak as much as she wants. Ask as many questions.
If that in that analogous circumstance, you are saying that because one does not specifically speak out about the narrow issue, that person may not be considered a limited purpose public figure. Is that your position?
Yeah, Your Honor, that is the Supreme Court's position.
I don't. Well,
yes.
I might disagree with that. I'm just trying to find out if that's your position.
Yes, Your Honor. And can I point the court to two important cases that were cited, one in our opposition brief and one in the amicus brief. Both of these cases were not addressed at all by defendant in their reply brief. The first is the Nan Tan Bu case, which is a case involving Martin Luther King. This was United States District Court, Southern District of New York, 816 F sup 218. In that case, Your Honor, the plaintiff, the defamation plaintiff, was a woman who was an active civil rights leader who had a huge reputation in the community, was well respected, and was involved in all civic activities. She knew Dr. King, and the night before Dr. King's assassination, Dr. King spent the evening with the plaintiff, with Ms. Nan Tan Bu. And in that case, right after Dr. King was assassinated, one of his colleagues wrote a book. And in that book, the book suggested that Ms. Nan Tan Bu had an extramarital affair with Dr. King. So she sued for defamation. And here's what the court said, and it's very important because it's quite analogous here. It says, the controversy into which a plaintiff has allegedly entered is defined as the event that the defamatory statements describe. The controversy in this case is not the publication of the book, nor is it, as the defendants seem to argue, the extent or nature of the plaintiff's role in the civil rights movement throughout her lifetime. Rather, the controversy is the question of events that took place on the last night of King's life. Even expanded, the controversy is at its broadest the question of King's involvement with women outside of marriage. And I'd like to point you to the other case, Your Honor, which is the Elliott versus Donegan case, 2020 U.S. District Lexus 114151, Eastern District of New York, that came down just a few months ago. In that case, Your Honor, the defamation plaintiff sued a magazine because they published a list of media men. I'll forget for the moment the characterization of the media men. But in that, he had been accused of sexual violence by multiple women. In that case, that particular defamation plaintiff had already written numerous books that had violent descriptions of sex and rape fantasies. But in spite of those extensive writings and interviews that he had done about sex, BDSM, and sexual assault, Judge Hall determined that for purposes of defamation lawsuit, he was a private figure because his writings were not about the controversy here, which was issues of sexual assault, sexual harassment, and consent in the workplace. So, Your Honor, here, the issue is drugging and raping of women. Now,
No, I disagree. It's his relationship to someone who he has a contractual relationship with. He took her in, he agreed to represent her and make her a star, correct? And whether his alleged sexual assault is a part of that is what the issue is here, right?
Your Honor, the gravamen of the
separate. He didn't meet her at a party. He didn't meet her on the street. It's all a part of that relationship, correct?
Your Honor, think about that for a moment, because if you take that premise to its logical extreme, every single person who works with someone else, who has interpersonal relationships with someone, whether it's someone who is the manager of a Target store and is involved in human resources, or whether it's someone who is a teacher or a professor, anybody who has a relationship with someone else, and that the business that they're working on depends on that relationship, cannot be simply, by virtue of that relationship, a limited purpose public figure.
No, but the question is not whether he's limited purpose. The question is whether it's sufficiently connected to his notoriety to bring it into the ambit. The question of whether or not the person is notoriety is a different question. And what I am saying to you is that if a Fox newscaster has a junior associate that the Fox newscaster harasses, that relationship is interconnected enough that if the Fox News person is a limited purpose public figure or has met that prong of it, then that controversy comes within it. You are saying to me the rape doesn't come in into the ambit of the relationship between the two, the relationship of him and his publicity, and that's where I'm disagreeing with you.
Yeah, Your Honor, the issue that is the subject of the defamation is the drugging and raping. I understand.
It's not that narrow. That's why I'm disagreeing with you. It is not that narrow.
Well, if you look at the evidence that was presented, Your Honor, the evidence that was presented, the articles that are discussed are talk about music production and songwriting. It's not, as defendants counsel would like you to believe, focused entirely or majority or even a decent amount on taking young women and molding them and putting them under his wing. That might have been discussed at various points, but the focus of the publicity that surrounded Mr. Gottwald was him as a songwriter and as a music producer.
Okay. And not as the person who found Kesha? You don't think that had anything to do with his notoriety?
Your Honor, whether or not he found Kesha has
I'm asking you, is that part of his notoriety, that he discovered Kesha?
Your Honor, certainly he discovered Kesha and her success.
And that is part of his notoriety, correct?
I don't believe that. I don't believe that particular relationship had anything to do with the subject matter of the defamation here. The issue here is drugging and rape, and unless, as the Supreme Court says, unless Mr. Gottwald thrust himself into the vortex of that subject matter, not the subject matter as to whether he had a relationship with Ms. Sieber or whether he made her a star, but the subject matter here of drugging and raping, just like in the Nantan Booth case, like in the Elliott case, the subject matter has to be narrowly drawn. Otherwise, you sweep in every single relationship that might have existed and make that person a limited purpose public figure, and that is not the law.
Okay, Mr. Steinberg, thank you so much. Your
Honor, may I address the sham litigation point for 1 minute?
I'll give you 30 seconds for that because we've had plenty of time on this already.
Yes, Your Honor, I believe Justice Scarpula hit it on the head here. Judge Schechter found not only that there were issues of fact here about whether or not there was any basis for the underlying claim, but there is ample evidence. There was ample evidence presented that the litigation was presented with ulterior purpose and ulterior motives. Ultimately, if the trier of fact finds that Ms. Sieber was lying, it will certainly prove that the litigation was entirely a sham. With that, I'll rest.
Thank you, Mr. Steinberg. Mr. Matilsky, you have a few minutes, but we know those few minutes tend to be enlarged on this case.
I won't say anything more, I promise.
No, listen, we're all asking a lot of questions. This is a very important matter.
He's muted. You're muted.
Thank you, Your Honor. I just wanted to start where Justice Scarpula left off. I mean, if you think that a public controversy is required, Dr. Luke has clearly spoken about his own relationship with the starlets that he represents, and the idea that the fact that one of the people that he got famous for, says that actually our relationship wasn't that great because he assaulted me, he raped me. The idea that that would not fall within that public controversy makes no sense.
Yeah,
But
what about Mr. Matilsky? What about what Mr. Steinberg seems to be saying is pretty much everybody can be, or anybody can be considered a limited public figure by the mere fact that they've basically engaged in seeking publicity for his trade or for his profession or in any other fashion.
Your Honor, the target manager is not going to be a public figure for any purpose. If somebody goes out and seeks publicity, affirmatively seeks publicity within their profession, yes, they will be, just like the belly dancer in James. Nobody's ever heard of her, except for people that go to the belly dancing place in James. Nobody's ever heard of the doctor in Park, right? But with respect to statements in that sphere, they are public figures. And Dr. Luke, first of all, is a general purpose public figure because he's no less famous than the Winklevoss twins. But just in terms of limited purpose, as I said, that if you think their public controversy is required, there is one. But I don't know how to convince you that one is not required any better than citing the Court of Appeals decision, the New York Court of Appeals decision in James. Such persons have not necessarily taken an active part in debates on public issues, but they remain nevertheless persons.
Counsel, this is Judge John. So, Counsel, this is Judge John. I have a simple question. Have we come to a point where that it gets less to be a question of law and more of a question of fact? Have we now crossed that Rubicon? Because
I don't think so, Your Honor.
Because you know what I'm. Okay, you know what
I know what you're saying, and I mean I think I can answer your concern. The reason it's not a question of fact is, first of all, there aren't any facts in dispute. It's just applying the legal standard to the facts. I don't think there's ever been a case that suggests that it would be. But
that may be true. But the notoriety part is what really gets me, because in terms of, we have all this now technology. And it would be interesting to me to see how the plaintiff is viewed worldwide, with this Instagram and all this other technology, because that may be a factor which, the Gertz and the Sullivan and all those other early cases didn't have that kind of dissemination and didn't have that kind of worldwide, global sort of ability to attract people or to get. I mean, that's a factor into whether or not someone's a public figure, correct?
It definitely is, and I think it just enhances his status as a public figure. He's got hundreds of thousands of.
Exactly. That's exactly right.
But, Your Honor, Winklevoss was decided last year. As you know, it was your case, Your Honor. It was decided last year. It had nothing to do with social media. It had to do with the fact that they put themselves out as experts on business. They willingly participated in all this publicity. And exactly the same thing is happening here. And just to be clear, there are 2,500 people on the walk that have a star. It's the Walk of Fame. How many people were chosen to be American Idol judges? I mean, the producers of American Idol presumably don't choose people that nobody would want to watch. But in any event, you don't have to decide whether he's a general purpose public figure, because again, the question for limited purpose is just whether he's sought out publicity in the area. And again, as James says, public figures may invite publicity only with respect to narrow interest, which is what happened in James and in Park. But here, as narrow as you want to define the interest, it certainly has to include his relationship with the young female artist that he has made famous. And the idea that he was famous after this complaint was filed clearly is wrong. Every bit of evidence that we cite is pre-2014. The idea that these magazine articles just mention him is nonsense. He has features, articles about him and the young women that he has made stars in the New Yorker, in Billboard, in The Guardian, etc., on the sham piece. Again, the question cannot be whether somebody is telling the truth or not. And I read the line from Sexter and Wallflash that these statements are absolutely privileged, regardless of malice, bad faith, recklessness, or lack of due care. Again, we don't think that they're right about anything about the motives for filing this complaint. And also, there's nothing wrong with filing a complaint with putting pressure on somebody. That happens all the time. It's basically what every class action is. But it doesn't matter what the motive was. The only thing that matters for the sham exception.
You don't So you don't think it's problematic to make allegations about that basically constitute a crime against someone in order to get out of a contract?
It may well be problematic, and they can sue for malicious prosecution. They can sue for abusive process. They can sue for sanctions for filing baseless claims. They haven't done any of that. They haven't even moved for summary judgment, right? But they could do that. The one thing they can't do is use the statements, the speech, as a basis for a defamation claim. That's what the absolute privilege protects, and the privilege is there not to protect the parties. It's there to protect the public. This is, again, Sexter and Warnflesh. The possible harm to individuals barred from recovering for defamatory statements is deemed to be far outweighed by the need to encourage parties to litigation, as well as counsel and witnesses to speak freely in the course of judicial proceedings. And that's why the very, very narrow sham.
That statement itself sounds like a balancing, right?
But the balancing has already been done. Right, the balancing has already been done in favor of a litigation privilege, and there's a very narrow exception for shams. But what shams mean is not real litigation. You file a complaint, you soil somebody's reputation, and then you walk away. But when you actually litigate a case, I mean, you're not only going to spend a ton of money, and especially a rape case like this, you're willing to relive the experience.
But accusing someone of a crime is defamation per se, right? So is that an exception to it?
Definitely not an exception. There's no exception to the litigation privilege. And it seems to me that, if anything, in these kinds of he said, she said cases, it seems like what they're saying is there should be some kind of exception for that. The jury should decide whether they're lying. But it seems to me just the opposite. I mean, there are already incredible incentives not for women not to speak publicly about rape, sexual assaults, and certainly not file complaints. And the idea that you should create an incentive, an exception for the litigation privilege in those kinds of cases is totally perverse. But we're not even, if anything, it should be stronger. But we're not even asking for that. We're not asking for the court to innovate at all. All we're saying is for the court to apply its precedents in Latcher and Manhattan sports restaurants and hold. The sham exception only applies if somebody doesn't actually pursue the litigation. There's absolutely no question, no dispute of fact that Kesha pursued her litigation through a motion to dismiss. That's what happened in Latcher and in Manhattan sports. And the court held as a matter of law that there was no sham in those cases.
Thank you so much, Mr. Martinez.
Your Honor, I know it's unorthodox, but I feel like I got a little bit of short shrift on time. Can I have 30 seconds?
Well, you got 20 minutes and they only got 10 minutes initially and now have gotten an additional 5 minutes. So I think we're good. I think we've heard enough from you. Very vigorous argument. Now it's up to us to make that tough decision, right? So I thank you both.
Thank you.
Thank you, Your Honor.
Okay. Labener versus Florist.
Good morning, Your Honor. Kara Rosen from Edelman, Krasny, and Jay for the appellant.
Good morning, Ms. Rosen. Do we have counsel for Florist?
Jerome.
And for 50 East 96?
Good morning, Your Honor. Sylvia Soto on behalf of defendant Jerome Florist.
Okay, I just want to make sure that everyone is on before arguments begin. Are we missing 50 East 96th Street?
No, Your Honor. David Blackie, 450 East
Okay.
96th Street.
I just wanted to make sure. So let me hear first from Appellate and Labener.
Thank you. May it please the court, the appellant here is arguing that the lower court improperly granted summary judgment to the defendants. With respect to the landlord here, I think that it's clear that it was error to grant the landlord's motion on the basis of an out-of-possession landlord defense, as 7210 imposes a non-delegable duty on the landlord.
Right.
So,
Xiangfu He already, the Court of Appeals has already addressed that issue, right?
yes, Your Honor. So I think that the real issue here gets to the evidence that was presented on behalf of the tenant Florist, as it's being relied on by both defendants in support of their motions. I think that here.
Well, the question is really, are you, by notwithstanding the Court of Appeals case in Xianfu He, the question is whether you are relieved of your obligation to prove negligence, right?
Well, no, I mean, here it's the defendant's obligation on the motion for summary judgment. It's their burden, Your Honor. So it's their burden here to establish that they didn't create the condition that we're alleging. I think the dangerous condition of snow and ice has been established by the testimony. So they need to establish then that they did not create or exacerbate that condition, and in addition, establish the absence of notice. I think with respect to the exacerbation of that condition, we have admitted snow removal that took place either 2 days or a day before this accident happened. And then we have general procedures of what that snow removal would have consisted that day, right? We have
we have the testimony, right? The testimony that Flores presented is that, one, they salted and shoveled the sidewalk before the accident and on that actual day, right?
Yes, Your Honor, but it's a very general testimony. There's no testimony as to who did it that day. He didn't do it, right? Whether he saw any of his staff members shoveling or salting. At best, even if you accept his testimony that they would have, which I would argue is entirely speculative here and does not meet their burden, that they would have shoveled a path, it would have only been 6 feet wide, right? Which leads me into questions of fact here, right? At best, it would have been a path that was 6 feet wide. The plaintiff testified it was only 2 feet. So we have a question of whether there was a path. Then we also have a question, you know, of whether those actions, if they had been done, would be reasonable. I think the lower court made a factual determination here in accepting that a 6-foot path may have been shoveled and that therefore rendered the sidewalk in a reasonably safe condition. And I think that it was error to do so. I think
did you raise any issue in opposition to summary judgment? Because I read Mr. Stamey's deposition testimony, and he says that he not only oversaw the snow removal procedure and made sure that his employees created a path, in this case 6 feet wide, right, and then salted. That's what he says at record 640.
He says, yes, that he would have made sure that they did that on that day. So what I'm saying is, right, he said that they did that 2 days before. The day of the accident, he looks out onto the Madison Avenue sidewalk from the inside the shop at 8:30. The accident then happens at 12 p.m., right? There's really no evidence as to what snow removal took place that day.
This is Judge Ong. I got a question. So what is your response to Mr. Stamos's deposition testimony that he saw a plaintiff sitting in an area of the sidewalk outside of the path created by Jerome Flores, where there was about 1 inch or 2 of snow? So how do you respond to that deposition testimony? What does your client say about that? Well, he said he saw him outside of the area that he took care of.
I think he said that he was on the boundary of that path. And with respect to the...
I don't think that's what he said. But
no, that's not what he said.
Okay.
Okay, well, even assuming he's not within this path, right? I mean, I would say...
Well, how can you expect... Well, if that's the case, how do you then argue that the defendants, that they have more responsibility than the 6 feet wide that's in front of their store then? I mean, if he falls like at the corner, you're going to say that the defendants are liable for that too? I mean, right?
The defendant in his own affidavit says that it is his responsibility to keep the sidewalk free and clear of snow and ice.
Not that means the entire sidewalk from the corner to corner?
That's what the affidavit says. The sidewalk in front of their store, which is 15 feet wide.
Let's look at the law here, though. Because that's what we're looking at. So if he falls outside of the boundary or near the boundary, that's not saying that he fell where the snow and ice was cleared.
But it's not clear that there was a 6-foot path, right? The plaintiff testifies that there was a 2-foot path. So we have conflicting testimony, and that's all the evidence we have here, the credibility of which is for a jury to determine, right, what that path consisted of, what the snow removal actually consisted of, and whether that's reasonable.
Did you also, counsel, offer any expert testimony about the refreeze, about a situation, because this was cleared at 8:30 in the morning, he fell around noontime, so about 3.5 hours later, 4 hours later, that there could be a freeze, a refreeze. Did you have any expert testimony on that issue?
There's no expert testimony as to whether there was a freeze or a refreeze here, but I would again say I don't think it's entirely clear that this was cleared at 8:30. And nevertheless, it was clear that there was snow and ice present on the sidewalk at the time that this accident occurred, right? No one's disputing that there was the presence of snow and ice. What is disputed is what snow removal efforts were actually taken and what the condition of the sidewalk was at the time of that accident, specifically with respect to the size of this path. That is a disputed issue of fact that I think is for a jury to determine, that precludes summary judgment here.
Thank you, Ms. Rosen.
Thank you.
Okay, let me hear from the cross appellant first.
Thank you, Your Honor. Just for clarification purposes, would you like me to address both the rebutting of the appellant's arguments as well as appeal at the same time?
Well, you cross appellant, so you got 2 minutes rebuttal. So how you allocate that time is up to you.
Thank you, Your Honor. May it please the court, I'm here today representing 50 East 96th Street LLC. We were the landlord of the building at issue. I would first like to point out that despite plaintiff's arguments that Mr. Stamos said his employees would have or would have removed the snow, the testimony was actually that he inspected the premises as he walked in to the
Mr. Black, I don't know whether it's just me, but I'm having difficulty hearing you. You're breaking you're breaking down. So let's see. Try it again and get closer.
I apologize, Your Honor. I didn't profess this, but I guess it didn't work out. Can you hear me now?
No, we still have the same thing. I tell you what, why don't we hear from Florist first? And let's see if we can get some clearing up of that audio at your end, okay? Susanna and Stacy, if we can help out with that. Ms. Salto, you representing Florist?
Yes, Your Honor. May it please the court. Good morning. Sylvia Soto from the law offices of Tramello and Fishman, and I represent Jerome Florist, respondent in this matter. It is our position that the lower court's decision granting the plaintiff's complaint should be affirmed by this court.
Counsel, this is
the evidence in the record established 4 very critical facts. One, that there was.
I think Justice Owing has a question.
I have a question. So let's get right to the heart of this.
Yes.
Your client cleared 6 feet. He testified, or he deposition cleared 6 feet in front of him. That the plaintiff fell outside or near the boundary. Did the plaintiff come back with anything saying that that's not accurate? That he fell where there was clear?
No, Your Honor. That's not my reading of any of the testimony. The only issue is whether it was either 6 feet or 2 feet, but even by any, in the light most favorable to the plaintiff, that it was 2 feet wide, that there was a clearing, that it was done reasonably, and even his wife was walking in that 2-foot path, which she testified to as a non-party and had no difficulty walking. There's been no evidence to create an issue of fact as to whether or not Jerome Flores created any condition that the plaintiff fell on. The testimony by the plaintiff himself at the record 657 says that he was trying to catch up with his wife, and he walked around people outside of the path at the time his accident fell. So there's been no evidence that, yes, Your Honor?
Ms. Sato, do you interpret your responsibilities under Administrative Code Section 7-2010 as basically an obligation to clear and maintain the area in front of your store, not beyond that, right?
Yes, Your Honor. The obligation is to maintain the abutting property in front of our store in a reasonably safe condition, which I think the testimony in the record met the prima facie case of Jerome Flores to establish that we did so. It's now the burden of the plaintiff to come forward with evidence that we did not. And by virtue of the testimony in the record, the plaintiff's own wife, and it appears that other people were also walking on the cleared pathway, that Jerome Flores did maintain the sidewalk in a reasonably safe condition.
Okay, thank you. Any other questions? Okay, thank you, Ms. Salto. Let's hear from Mr. Black. Mr. Black, you're still muted. Can you hear me?
Uh-oh.
Yeah. Counsel for.
Oh, he's up.
Yep. You up?
I'm sorry, can you hear me now?
Yeah, it seems that you have a very low connection, but you know, let's try to figure it out.
Okay, I can call in if you prefer, Your Honor. That was a
No, it's fine. Just go ahead.
Okay. We agree with Jerome Flores and their arguments that even given the testimony in the light most favorable to the plaintiff, that there was a clear path that was established by testimony from both the plaintiff and the wife. We would also agree that the court found correctly that even given the plaintiff's description of the path, that it was available for him to use and it was reasonably safe, which is the standard under the admin code 7-210.
So, counsel, let me ask you a question. This is Judge Oing. So this case rises and falls on Jerome because clearly your client didn't do anything with respect to this clearing this area, correct?
That is absolutely correct. I would also like to point out, though, that we did not raise the out-of-possession landlord defense in our summary judgment motion papers. The judge brought that in on themselves in their decision, which obviously is their right to do so. Right. But we did not rely on that in our papers. We relied on the fact that Jerome Flores met the standard. And even in the Jean V. Truin case, it was stated by the Court of Appeals that you are still allowed to delegate to a tenant or a third party, even though the duty may or may not, or even though the duty is still applied to the landlord.
Right, but it is not a strict liability statute.
I agree with you, sir. It is not.
So, counsel, let me ask you on your cross appeal. If we were to affirm, is your cross appeal then in terms of seeking cross claim for contractor indemnification? That's moot then, no?
That is correct. If you affirm, then the cross appeal is moot.
It's a different story if we reverse, clearly.
That is the exact premise of our cross appeal. If you reverse, I believe that the record is very clear that Jerome Flores accepted responsibility for maintaining the sidewalk free and clear of debris, that they accepted the lease that had been in evidence or had been in existence since 1929, that they were to indemnify the landlord for any negligence stemming from that responsibility. And the fact that the Hugh versus Truin case was decided after does not change that. Right. The court in that case also said that indemnification actions were still permissible.
Right.
Okay. Thank you, counsel. Let me hear from Ms. Rosen back on rebuttal.
Thank you, Your Honor. I just wanted to address the record at 657 is with respect to Mr. Stamos from Jerome Flores saying what he thinks happened and that, that the plaintiff was catching up to his wife. He did not witness this accident and the plaintiff never said that that's what he was doing. And just coming back to this clear issue of if there was a path, right, what the size of that path was. Was it 2 feet? Was it 6 feet? And if there's a question on that issue, then I think that there is a clear question as to whether or not the actions taken were reasonable and that this question is clearly one for a jury.
Thank you so much, Ms. Rosen. Thank you all.
Thank you, Your Honors.
Thank you, Your Honor.
Thank you.
S. Scott versus Stephanie L.
Hi. Scott Stein as applicant here.
Okay. Good
Yes,
morning, Mr. Stein. Good morning, Ms. Levine.
Good morning. I'm Stephanie Levine.
Let me first hear, Ms. Levine, you representing?
Myself.
Okay. And Counsel, Mrs. Stein?
I'm representing myself. I'm the appellant and pro se.
Okay, so let me hear from Scott, from Mrs. Stein.
Thank you and good morning and happy almost Thanksgiving. I'm appealing this case because I believe that the Honorable Shim abused his discretion in denying a hearing on my downward modification request of both my child support and the percentage of add-on expenses I pay based on the evidentiary submissions from both myself and respondent, which disclose genuine issues of facts. And in the case of add-on expenses, they were denied to be heard because the family court said they didn't have jurisdiction, which I believe they do. I currently pay $4,000 a month in child support and 92.5% of add-on expenses, which has never been modified, which approximates another $6,000 a month.
Mr. Stein, so the question is really whether there has been a substantial change of circumstances in your case. The court found that there wasn't a substantial change because in essence, your income, once it was downwardly modified, did not change much from 2016 to now, right?
Well, first of all, when I entered into the agreement in 2016, I was unemployed for 4 days. I did not anticipate at all that I would continue to be unemployed for 5 years. The law is pretty clear that when they look at a downward modification to see if it's warranted, the party must show if they've engaged in a diligent search for a new job, which I have. It's undisputed. I produced.
Yeah, I don't think that anyone is disputing that. I think the underlying issue is whether your income has changed significantly, and we're still talking about basically the same amount of income, correct?
My income in 2019 was $128,000. So there is a substantial decrease, but more to the point, the courts look at other factors to determine whether there's been a change in circumstances. Firstly, for the first time, as part of this hearing, respondent submitted an updated child support needs analysis, which is critical to whether a modification should be warranted. By her own affidavit submission, the child support needs analysis she submitted showed a significantly lower child support amount than the $4,000 I'm paying. The other factor that people look at, that the courts look at, is whether there's been a substantial increase in wealth in the parties. Respondent had on the record, had a $55,000 net worth when we got divorced. Today, she's accumulated 3 luxury residences amounting to about $8.1 million with her husband. That is undisputable and a substantial increase in wealth and needs to be taken into consideration. Respondent is perfectly capable of working as a speech therapist, yet she refuses to work. If you look at the transcripts in June to the support magistrate, she actually introduced herself as a professional speech therapist. She went on to state on the record that how she chooses to spend her time, whether I do philanthropic work or pro bono speech therapy work, should not even been discussed in this court, which I disagree. Both parties are responsible for the financial and economic well-being of our children. So what I'm saying is that if you look at all the facts holistically, there has been a substantial change in circumstances. She has no income imputed to her for child support purposes. The percentage of add-on expenses of 92.5% has never been modified or litigated. So that is something that is new. So I do believe that with all those factors, there are numerous changes in circumstances that warrant a hearing.
Okay, thank you, Mrs. Stein.
You're welcome.
Let me hear from you, Ms. Levine.
Sure, yes. Good morning.
Good morning.
Thank you. So I would like to go back to what you started. Excuse me, do you pronounce your name Acosta or Acosta?
Acosta.
Okay, so thank you. So Judge Acosta, you just stated what I believe is the heart of this case and what I will mention not only what I believe, which isn't as significant as what the professionals believe, and that is the underlying issue isn't whether or not my ex-husband should tell me to work. It's about the fact that he did not show the court in any form of evidence that he met the burden in proving a substantial change in circumstances which would warrant the downward modification of his child support obligation. And as I said, the professionals say support magistrate Melvin Delary in July of 2019 from the lower court, and when we returned to court in February of 2020, the presiding judge was Jonathan Shim. They both ruled against Mr. Stein and that he did not prove such a change in circumstances. But specifically, he did not establish that his financial circumstances deteriorated in any way. And not only that, he doesn't, this is to quote Honorable Shim, he not only lacked he lacked not only the means, and in other words, he does not lack the means nor the ability to work to meet his $4,000 monthly obligation. And more importantly, what I want to say, when he filed the original petition in May of 2018, he stated that his income was $200,000. Well, fast forward, he repeatedly refused, this is all on record, he repeatedly refused to show documentation. Then finally, when we went back to court, he submitted documents that showed his correct income to be $509,907. But in the recent hearing, then he goes on to admit that in 2017, his income was $520,000. So now if you do the math, the appellant's income, ironically, actually slightly increased since the 2016 stipulation. Now, to quote Judge Shim, in his decision that was issued February 2020, he states, Mr. Stein simply did not demonstrate this, as his 2017 financial documentation depicts anything but a depletion of his other financial resources. And in addition, he noted that this, to quote a case, Carr versus Carr, that case coincides with Mr. Shim, Honorable Shim's conclusion that Mr. Stein's significant expenditures on luxuries, such as private school tuition for the non-subject child, that's his other daughter, kitchen remodeling that he's done, he's taken European vacations. And one other thing that I just want to say that was not noted in any of this paperwork or documentation, which I feel is very pertinent. So he talks about me and my lifestyle and my behavior. But what I want to point out that I take pride in, when Mr. Stein came to me in December of 2015 and shared that he lost his job at JP Morgan, where he worked for over 2 decades, he asked me, we met in the lobby of my building. So to avoid more legal fees that we already spent way significant amounts, as you can imagine, through our divorce proceedings, we met in my building on East 72nd Street in New York. What we discussed and agreed upon was that this child support that originally was $5,000, we would lower it to $4,000. So I just want to say that wasn't even presented, but I feel like because this is dragging on, because he has this vendetta against me, I want to say that without any legal support, he and I face-to-face, 2 parents of our daughter. That was 5 years ago. She was 10 years old at the time. We agreed. So we lowered it to $4,000. Okay. Secondly,
you have another, I'll give you another 30 seconds.
More important point. I'm the mother of 2 daughters. My younger daughter's 10. Sammy's almost 15. The child here now, I don't know if any of you raise teenagers, are raising, know about teenagers, but I will attest that Sammy's expenses are not going down because there are so many expenses that as a teenager that she's incurring that I didn't know until it came time to raise a teenager. So I want to say what the affidavit is actually not based on a teenager, and the expenses are just going up. So thank you for your attention.
Thank you.
And
Thank you, Ms. Levine.
thank you. Okay. So
Mr. Stein, I'll give you 1 minute.
Thank you. First of all, as I noted, Honorable Shin made his decision. He stated that in his response, he wrongly imputed income and assets to me based on respondent's fraudulent, incorrect statements. Respondent said I took a vacation. My wife paid for that. Respondent said I remodeled my kitchen. My wife paid for that, and I gave evidence to the courts and to her, and she knew that. Third, I sent my second child to a private school, the same private school that the respondent sends her second child to. My wife pays for that. I've tried to cancel checks. Second of all, the expense affidavit submitted by respondent was a couple of years ago, so it does include Samantha's actual teenage expenses. And third, most of the cases that Honorable Shim cites are based on a party who did not and was viewed to not provide credible evidence. They put in a good faith effort to find a new job.
Okay.
What I'm saying is the respondent has every ability to work. Her income should be imputed. She doesn't have to take care of either of their kids. They're grown up. She has all the time and the capability to work as a speech therapist.
Thank you.
My add-on expenses have never been modified, sir.
Thank you, Mr. Stein.
Thank you very much.
Thank you both.
may I just add one thing?
No, you may not, Ms. Levine. It's only, you don't have rebuttal time. Only the appellant does.
Thank you. Happy Thanksgiving.
Okay.
Thank you both and have a happy Thanksgiving.
Thank you. Same to you. Okay, thank you.
Ishaki versus Ishaki.
Yes, for the appellant, Kevin McDonough, for Nina Izaki.
For the respondent, can the judges hear me?
We can. Let me first hear from appellant.
Yes, well, I didn't introduce myself. Philip Greenberg, attorney for respondent, cross appellant Daniel Izaki. Now we're good.
Thank you, counsel. Mr. McDonald.
Thank you, Your Honor. May it please the court. My name is Kevin McDonough, and I'm a member of the firm of Mantel, McDonough, Riso, attorneys for the appellant Nina Izaki. This appeal presents a discrete and straightforward issue for determination by this court, to wit, whether a litigant's contemptuous behavior in refusing to comply with the multiple orders of the lower court, specifically refusing to meet his court-ordered discovery obligations related to his multi-million-dollar business, which resulted in a preclusion order pursuant to CPR 3126 being issued by Justice Gesmer, has any consequences whatsoever. According to the defendant, the court should countenance his refusal to allow his business to be appraised, ignore the evidence of value which came from defendant's own mouth to federally insured banking institutions under the threat of criminal prosecution, and then charge plaintiff with the business debts of that business and force her to sell her home and that of her children, a home which she has exclusively carried and paid the overhead carrying expenses for 10 years, while defendant defaulted on his interim.
Mr. McDonald, how do you suggest, just with respect to that issue, how do you suggest that the underlying debt be satisfied, the underlying debt for the marital property? How would that be satisfied other than through sale?
Well, pursuant to the referee's report and pursuant to our position, there are multiple debts associated with the marital home. There are two mortgages that are in the joint names of the party with Chase Bank. Her receipt of the title of the home would be subject to those mortgages. She would indemnify him with respect to those mortgages. With respect to the Sperry and DLL loans, which are the business loans that were taken out of the name of his business, but which he personally guaranteed. And then with respect to the DLL loan, he put a mortgage on the jointly owned property without her knowledge, which is undisputed. He would be responsible for those, and he can use the monies from wherever he gets it, presumably from his multi-million-dollar business, which is ongoing. So it's defendant's position that all these business debts, which are unquestionably business debts, should be charged to the marital fisc and paid by the plaintiff. If that's the case, and if there's the court concludes there is no value to his business, then CPOR 3126 really has no effect whatsoever, and there are no consequences. That's his position. He's wrong. As the appellate division in the Steinberg case said, under very similar circumstances to those that are presented to this court.
Does the referee, does the court provide some analysis with respect to some of those debts not being solely the husband's, but instead decided to treat them as marital property? What was the basis of the referee report on that?
So the referee found that the DLL and Sperry loans, which were both business loans of his business, should be paid by him because the referee repeatedly found that his business was ongoing, that there was millions and millions of dollars being generated, that he could have used to pay those loans, that he purposefully didn't pay those loans, thus essentially resulting in dissipation of property. Again, this is a very old case. This is a 2011 index number. He defaulted on these loans in 2010. The referee specifically found, and Justice Katz even found, because he held him in contempt and incarcerated him, that there was tons of money coming into his business after the default of these loans. He used that money to pay his own expenses, traveling the world. The court refers to his luxurious lifestyle, rather than paying these debts. And in the interim, since he defaulted back in 2010, the amount of the DLL loan, with all the interest that's accrued, has ballooned to with another $1.7 million of unpaid interest, such that that loan today, which the lower court did not address, and I think misapprehended, there is no equity in. If the DLL loan was paid on a sale of these apartments, the defendant is getting nothing out of these properties. All that he's doing is being rewarded for our client being given no credit for the value of his business, a business that he swore to federally insured financial institutions was worth $10 million. She's being stuck with those loans, and she's getting no credit for the value of that business. And under Justice Gesner's preclusion order, that's not an appropriate result. You can't say, I'm not going to produce the documents relevant to my business. I'm not going to allow it to be appraised. And therefore, because of my own contemptuous behavior, which resulted in an explicit order from Judge Gesner, you get no value for the business. And at the same time, I'm going to stick you with the business loans, which I took out in my own name. So after hearing 16 days of trial testimony, we submit that the lower court erred in not confirming the referee's report, which concluded that plaintiff should be awarded the marital home. Defendant should be solely responsible for the debts of his business, which he allowed to lien that home. The referee explicitly rejected defendant's self-serving position that his wife should be stuck with his business debts while he walks away with the multi-million-dollar value of that business scot-free. The defendant repeatedly says in his brief, and there's a very dearth of record citations. He repeatedly says, we've asked that 100% of the marital assets be awarded to the plaintiff. That's just not so. What we have said is that under Justice Gesner's order and under CPOR 3126, the value of his business must be taken into account in determining the assets. And if you include the value of his business, net of these business debts, he is getting close to 50% of the value of the marital estate.
Thank you, Mr. McDonough.
Thank you.
Okay. Mr. Greenberg?
Yes, thank you, Philip Greenberg, attorney for defendant, respondent, cross-appellant Dan Izaki. The opposing argument goes into a lot of things that were outside the record, but to the extent that they were in the record, the record reflects, no, these business debts were not taken without the knowledge or consent of the plaintiff. Secondly, these debts resulted from the same business that previously provided most of the assets and most of the income to acquire these assets, and also, as to our cross appeal, enabled the plaintiff to finish dental school and establish her dental practice while the defendant was supporting the family. As far as the business, that, with all due respect to Mr. McDonough, his own client at the hearings repeatedly acknowledged, and they actually argue in their briefs, there is no business. There is no multi-million-dollar business. Defendant, it's undisputed, defendant has been out of business for years. So for him to say that Mr. Izaki, lucky Mr. Izaki, he's getting 60% of this business, which both parties agree is worth nothing, and somehow that translates to 50% of the marital pot, is contrary to the record. It's contrary to plaintiff's own arguments in a lower court and plaintiff's arguments on this appeal. So therefore, most definitely Justice Katz got it right when he said that beside the fact that he overturned the support awards, which appellant doesn't even appeal from because they were so outrageous, and similarly outrageous was giving all the marital assets to the plaintiff, even though it's undisputed that they both worked together and for many years defendant was the principal source of income. And as far as the cross appeal goes, the referee got that wrong also, because the dental practice, just because the dental practice has no book value, doesn't change the fact that a law practice, a dental practice, is valued based on its goodwill. And it's undisputed that Dr. Zaki and Mr. McDonough keeps referring to Justice Gessman when she was the trial court judge. She found that Dr. Izaki, plaintiff Dr. Izaki, was the moneyed spouse. So this dental practice, by definition, has a value because she is making an extremely good living, much more money than the defendant is earning from that dental practice. So the dental practice has value. It was acquired during the marriage. It clearly is marital property, and Mr. Izaki is entitled to a percentage of the value thereof. And as for the bill,
Counsel, let me interrupt you for a second. Isn't it true that the court-appointed neutral found that the practice had no value?
Yes, and the
wasn't the referee entitled to rely on that?
The referee was entitled to rely on it,
so I don't see how that could have been error.
Well, because the referee and the appraisal was something for the referee to consider, but just as he misconstrued the facts and the applicable law and the testimony, the applicable law, and it was undisputed that the plaintiff makes a very substantial income from that.
Wait a second. You have an expert that testifies and puts in a report that says this is worth nothing. And there's nothing to say that there's any bias in that report. It's a neutral evaluation. And so I don't understand how you could possibly say that it was error for anyone to rely on that neutral evaluation report. What was error about it?
Because the undisputed facts is that the plaintiff earns an extremely good living from that practice, and the case law, as we cited in our reply brief, puts a value, even if there's no value, and two of them were dental practice cases, even if there's no.
But the value is not the value that the income that she generates out of it. Is the underlying value of the entity itself, of the practice itself, right?
Not when it comes to a dental practice or a law practice, because I'm much closer to the idea of law practice having value. But no, and again, the cases that we cited in our reply brief were dental practice cases, and where the same kind of argument was made that the dental practice has no value. But that didn't change the fact that it was undisputed, as in our case, that the dentist involved was making a very substantial income, substantially more than he or she would make had they just had a college degree. And so the appellate courts in those cases, as this court should still find that there's a value to this dental practice, It's undisputed that it's a marital asset. And so the respondent cross-appellant should receive a percentage of the value of that dental practice.
Thank you, Mr. Greenberg. Let me hear in rebuttal from Mr. McDonald.
Just briefly, Your Honor, this is the problem which has pervaded this case throughout. The defendant just makes statements which are demonstrably false. It is admitted, it is undisputed. It is the referee found it, and Judge Katz found it as well, that his first business in name TTS was converted into PCS to avoid paying his creditors. That is undisputed. It is undisputed that in the period after he changed the name of the company, put it in his sister's name, and admittedly used it to pay his personal expenses, he admits under oath in his own papers he did that to avoid his creditors. That business generated millions and millions of dollars in the period from 2010 to date. It did exactly the same thing, selling computers and related electronics to Costco. And for anyone to sit here and argue that it's been out of business for years, it's the whore's the record, and it's just not true. And this is the kind of statements that have been made by the defendant and his attorney throughout these proceedings in an attempt to not only defraud his creditors, but to defraud his wife. After a decade of her carrying this home for herself and for her two children, which she's the sole custodial parent of, and Mr. Izaki will not get a dime if that apartment is ordered sold. All he is doing, and the only reason he is doing it, is to try to throw his children into the street. And we submit to this court that it was an abuse of discretion for the lower court not to accept the referee's report, not to allow her to maintain her home as an offset against his business value and the business debts of his that he allowed and purposely put as liens on the marital home. Thank you, Your Honor.
Thank you,
Happy
Mr.
Thanksgiving.
I'm entitled to
Ms. Greenberg has.
Yes.
Ms. Greenberg, you have 2 minutes in rebuttal on your cross appeal.
Yes, thank you. Well, since the two appeals are so intertwined, I just want to point out that everything that's said about that there would be no value if the apartments were sold, there's no evidence, there's nothing in the record supporting that. And as far as Mr. McDonough's claim that we have made the demonstrably false statements, everything that we have said in our briefs and in his oral argument are supported by the record. So we stand on that. And finally, any claims that Mr. Zaki may have tried to avoid his creditors perhaps is an issue, perhaps, even though Dr. Zaki and her lawyer in the lower court asked Justice Katz to give them the apartment so that they could avoid those creditors. In other words, they asked for assistance in avoiding those creditors. But in any event, all the arguments that Mr. McDonough made regarding those creditors perhaps is an issue between Dr. Zaki and Mr. Zaki and those creditors, but it's certainly not an issue on this appeal. I thank all of you for your attention, and I wish everyone, including Mr. McDonough, a happy Thanksgiving.
Thank you. Thank you both. Happy Thanksgiving. Willow be operating?
Good afternoon, Your Honors. Andrew Celli for the petitioner appellants, the Willoughby Companies.
Are the other parties on the line?
Yeah, Jeremy Schrader for the municipal respondents is here.
And Richard Coppola on behalf of Respondent Downtown Brooklyn Partnership is here.
Okay. Let me first hear from Mr. Shelley.
Good afternoon. Your Honors, Justice Edmeade's dismissal of the Article 78 petition in this case was erroneous for 3 reasons. The first is because Willoughby did coordinate site access with its neighbor, JEMB, and EDC had absolutely no basis to conclude otherwise. The second reason is that Justice Edmeade ignored EDC's 2 other reasons for bouncing my client from the project, And neither of those reasons have any merit, and we're prepared to talk about that today as well. And third and finally, Justice Edmeade erred because she essentially found that under no circumstances can there be any discovery in the context of an Article 78. And there are many cases that say that that's not so, and we've demonstrated that discovery is appropriate in this context. Let me go right to the issue of Willoughby's coordinating site access with the neighbor, JEMB. There were three elements to it: the creation of a safety zone, the permitting them to operate a crane over the property during construction, and the creation of protective covering. Those issues were absolutely not in dispute at any time between Willoughby and JEMB. In fact, the Finkelman affidavit says this very clearly, and better still, the correspondence between the parties shows that at all times, Willoughby was prepared to have JEMB do those things so it could work on its property and we could work on our property. The issue that was in dispute is something that EDC created that was never mentioned in the December 10th letter that laid out the requirements for our client and that we had no control over. And that was the foundational supports. There was a lot of fighting over the foundational supports, but that had nothing, I mean, we were sort of stuck in the middle. EDC creates the problem, it allows them to bury these supports, doesn't even tell us it's going to do that, and then says, you know, go see if you can figure out how they're going to come out, costing millions of dollars. And they crossed their arms and they said, we're not going to help in any way. That agreement was between EDC and JEMB. We were not a party to it. We had nothing to do with it. And the December 10th letter that sets forth the requirements for Willoughby doesn't even mention the foundation supports. So I think where Justice Edmeade lost sight, what she lost sight of here was the very narrow nature of the requirement in the December 10th letter to coordinate access. That letter does not say there has to be a written agreement. There wasn't a written agreement. It doesn't say there had to be a written agreement. That letter does not say a word about foundational supports. It simply references coordinating site access, and I think even the respondents will agree that that means the safety zone, the operating of cranes, and the protective covering, and there was never any dispute that Willoughby was prepared to and willing to and eager to permit JEMB to have that access.
So this is Judge Scarpula, right? There were three things that you had to do. First of all, the whole deal had fell apart. There's no dispute that you didn't get the financing previously. And then you came back and then you said, please, please, please let us continue to do this. And then there was a letter that said, okay, here's the last ditch. Three things. One is an agreement with DBP, correct?
I would quibble.
I read the letter. That's what it says.
It doesn't say an agreement. It doesn't say an agreement. It says to come to business terms.
Mr. Shelley, please allow the justice to finish her question.
Of course, I apologize.
So, was there an agreement by the date that you were required to have an agreement?
Your Honor, the answer is yes. There was a memorandum of understanding.
Was it executed?
It was executed by our side.
Before or after the date that it was supposed to be executed by?
I believe it was executed before, but
I think it was after. I think it's clear from the record it was after. And one, and two, was that MOU being negotiated and edited and redone after the date that it was supposed to be signed by, right? January 21st was the date it was supposed to be signed. Your guy didn't even sign it till the 23rd. And the other side was editing it after the 21st, correct?
If I could,
do you agree with all of that?
I agree with that, but there are aspects of it.
That ends the whole discussion. You did not come to that term.
Your Honor, we had until the 27th. First of all, the interim dates were never material. They were never even given as a basis for bouncing us off the project. They didn't say that in the January 30th letter, so that's important. We had until the 27th, and the letter from December 10th does not say that it has to be a signed written agreement.
When was the well? You needed to have a coordination agreement, right?
No, just coordinate access.
What was the scheduled closing date?
It had to close by the 27th of January. And all of these things had to happen before that. And they required EDC to cooperate and other parties to cooperate with my client to get to a closing, like in every closing. But I do want to come back to Justice Garpulla's point, because I think it's a very important one. The December 10th letter does not say there has to be a signed written agreement. It says you have to come to business terms with the Downtown Brooklyn Partnership, which
so
we
let me just interrupt you, and we agree. Okay, even if I agreed that could that it said something other than you have to have a binding agreement, there is no possibility that you have a binding agreement, right? That's what the letter says, a binding agreement, when at least one side is redlining it after the date that it's due. There's just, I mean, it's straight up. And your client signed it, but the other side never agreed to the terms that you're saying were the terms. Right? They're redlining it after that date, 4 days before the closing. So come on, I mean, let's be real.
Your Honor, what was agreed to by the parties, I'll come to the redlining in one moment. What was agreed to by the parties in the exchange of the MOUs was who was going to pay for the park, who was going to build the park, what it was going to look like, and the fact that the Downtown Brooklyn Partnership was going to get $500,000 for its own improvements. If you compare the two drafts, which are at R230 to 232 and on the record at 1221 to 1223, those are the competing drafts, the red lines. They're virtually identical, and they're completely identical on all of those points. There's some niggles and twits about.
Wasn't there agreement, at least by DBP's president, that a number of issues still remain outstanding, even as those MOUs were being exchanged?
She says that in an affidavit filed in this litigation. But
Okay.
if you compare the two documents and the fact that you have a board member who says this is ready for signature, it's not the case. The only issue that is even being discussed in the back and forth is whether it's going to be 30 days or 10 days for this or that.
Were there other conditions, Mr. Shelley?
I'm sorry?
Were there two other conditions?
So
You have a little time, so.
Thank you, Your Honor. So we've talked about the coordination of access. I've spoken about the issue of the agreement with DBP. Then there's this question of the financing. They say we failed to get the financing. Your Honors, there is a commitment letter. It's dated December 31st. It's prior to the January 3rd letter that EDC wrote to the mayor, which says they have a financial commitment. That's been confirmed. That's also in the record.
Weren't there a number of conditions precedent to loan disbursements?
There were issues that the lender was having with problems created by EDC. And this is where I talk about what is a closing really about. A closing requires the parties to all cooperate with each other to get to the conclusion. What happened here was EDC failed to renew the special permit. They had to run to the mayor at the last minute and get a special permit renewed through a mayoral zoning override. And they put new language in there that was different from what had been in there for the last 6 years, which required some explanation. And when we said to them, simply write our lender a letter explaining that new language, the commencement of construction standard under the multiple dwellings law, they crossed their arms and refused. So yes, there were problems with the lender having an issue with EDC, but we delivered everything that we had to deliver in terms of a lending commitment.
Thank you, Mr. Shelley. Let me hear from the respondents. Mr. Schrader.
Thank you, Your Honor. Jeremy Schrader for the municipal respondents. May it please the court. What I noticeably failed to hear from my colleague was anything about the standard of review here. And I'd like to remind everybody, this is an Article 78. So the question is whether it was rational for EDC to determine that they hadn't met the requirements to get to a closing of the December 10 letter. And under no view of this record could it be said that it was arbitrary and irrational.
Counsel, I have a question. I just have a question. This is answer if you can. What happens now that the deal was? I mean, this deal went belly up. I mean, they didn't get the finances. You stopped just continuing. You stopped the discussion or participating with the appellant, what happens? Does nothing get built? I mean, I'm just curious.
Well, so there is no plan right now to build an underground garage. That is not happening. There is a plan to
build the top part.
To have an open space there. Right now, it's temporary. You know, a lot has changed, obviously, in this world.
I was just curious.
It's part of the oddity of this case, because what they want is an order saying return to negotiations. That's all this is about, right? It's a very strange Article 78 to begin with. You know, I can go through all the reasons, the 3 reasons, the timing, and go through that. It's all in my brief, but there's a couple, I'll say a couple things about that. But first, just a couple of threshold points here. There's no dispute that the requirements of the December 10 letter were legitimate, totally valid. Willoughby has never challenged that, even though some of them required some coordination with third parties that might have been a little bit out of their control. Willoughby doesn't challenge that. They accepted those as the last-ditch attempt. I also...
This is Judge Scarpula. May I just ask you a question? Counsel said that the closing date was the 27th. I thought that it was the 21st.
You are correct, Your Honor. That was the agreed-upon closing date. The 27th was the drop-dead date for the permit. Everybody had said, we're going to plan to get this done by the 21st. But it doesn't really matter, either one of those dates, because they didn't make the timing, whether you look 2 weeks before the 27th, 2 weeks before the 21st, it doesn't matter. A lot of what Willoughby has done here is say, well, I think their point really is that EDC has somehow sabotaged their...
Right. I mean, they're basically saying you were not acting in good faith, that a closing requires cooperation, and they feel that you didn't quite live up to that obligation.
Let me address that, because the record here makes that so clear that cannot be the truth. So what happened is on, I guess it was December 4th, I think is what it was, or whatever it was shortly before the December 10th letter, when Willoughby came to EDC and said, we really want to try to get this deal done. We think we can get a lender. And we said, don't do this. We strongly urge you not to go forward with this. We don't think you're going to be able to get everything done in time. You've got to get it done by the January 27th. We don't think it can happen. So this idea that we kind of let them go forward and then pull the rug out from them, it just is totally inconsistent with everything that happened. It's also inconsistent with the years of efforts that EDC made to try to get this done, allowing them to proceed without a PLA, getting mayoral overrides over and over again for various things. I mean, you can just see that EDC wanted this to happen. They didn't do anything to try to prevent this from happening. I'm just going to make 2 quick points about...
And this, Judge White, and the other observation I have is that you really, I mean, you had the discussions with the appellate, but the appellant had the obligation to go forth and have deals, cut deals, or at least get into contracts with other non-parties that you don't have a control over, right?
Right, and they agreed to do that.
Yeah, they agreed to do that. So there's nothing on you. I mean, what else can you do? Because you're not, you tasked them with the assignment to go.
Oh, the city can do a lot, Justice Owen.
Well, we can't, but the point is they agreed that they were going to reach agreements with these people, and that was part of the deal. Right. They could have said, no way, we're not agreeing to those terms. We can't control them, but they didn't do that. So just 2 things. I mean, if you want to talk about the inability to get a binding financing commitment, which of course included, it's in the letter at 154, the December 10th letter, you needed to have the lender complete due diligence. You can just look at, if you want to look at one document, though there's a lot, it's in the record at 1067. This is January 24th, 3 days before the drop deadline. Willoughby comes to EDC and says, our lender is not going to close until we have a firm deadline from JEMB about when they're removing those supports. So the question is whether it's rational for EDC at that point or 3 days later to say, you haven't gotten a binding finance commitment. In fact, 3 days ago, you told us your lender wasn't going to close. I mean, how can that be irrational at that point for EDC to make that decision? Second point is, I think you're exactly right. The justices who have talked about the inability to get an agreement with DVP, they proceeded under a memorandum of understanding. That's how they tried to get this done. They did not get it done. They didn't have a signed one. Their own principal didn't sign it, and they've admitted in this case that he never sent a signed document in. He signed it later, which shows that really it's important to have a signed document. But there's no way that it was irrational for EDC at that point when they've been trying to proceed under an MOU and couldn't get it done to say you didn't really reach an agreement. Okay. I'll answer any other questions we have about the details of this. I think it's all in our brief, and I think I've probably addressed it here.
I think we're good, Mr. Schrader. Thank you very much. Mr. Coppola?
Good afternoon, Your Honors. May it please the court. My name is Richard Coppola. I'm an attorney for Respondent Downtown Brooklyn Partnership, and I will be brief. Downtown Brooklyn Partnership is a not-for-profit corporation that manages business improvement districts in downtown Brooklyn. It was designated to lease the open space portion of the proposed property and was responsible for the necessary repair, maintenance, and capital improvements for the open space. Downtown Brooklyn Partnership never reached an agreement with the developer Willoughby for terms on a memorandum of understanding, which was to outline the parties' understanding regarding the design and construction of the open space portion of the property located at Willoughby Square in downtown Brooklyn.
What would have been the nature of that agreement, Mr. Coppola?
My understanding, Your Honor, was my client would be responsible for, in essence, they would be entering into a lease.
I mean, basically, Willoughby's wanted a guarantee that GEM would remove the foundational support from underneath Willoughby Square by the 19th of March, right?
That's correct.
Was that ever?
That wasn't an issue with, that wasn't on the table with my client. That was not in communications with my client. The record, in my opinion, in my understanding, does not reflect that.
Okay.
The memorandum of understanding, Your Honors, was never signed, and as a result, it was not a binding agreement. Willoughby failed to resolve outstanding business issues, as is stated in the record in an affidavit by the president of Downtown Brooklyn Partnership, Regina Meyer, in that it was failed to resolve outstanding issues relating to design development, construction documents and warranty, budget and escalation, construction management, and how the turnover process for the open space would be implemented. The record is clear that the memorandum of understanding was executed by the developer after the deadline imposed in the December 10th, 2018 letter. And unless the court has any other questions, I rest on my brief and the arguments made in the city's brief.
Thank you, Mr. Coppola. Mr. Shelley.
If I could just say a few things, Your Honors. There is no dispute that there was no closing. I mean, I think that we all know that. The question here is really one of fault. And the fault lies with EDC, because at each and every step along the way, where there was something that EDC had to do to assist us in getting through all of the steps that they laid out for us, they not only failed to help, they really threw up roadblocks. And this started prior to December 10th, the December 10th letter. And this narrative that they gave us a last chance and we were the bad actor. The EDC allowed the special permit to lapse, which created a huge problem of having to rush to the mayor to get an MZO in order to get this project back on track. So the idea that there wasn't...
So I have a question. So, I'm going back to what the city's attorney said. You're asking us to compel EDC to start talking to you again. How do we do that? They stopped talking to you. How can we? Is it mandamus that you want us to compel them to come back to the table?
Yes.
And particularly given that the deal is no longer the same deal anymore. Things have changed. So what are we going to do? If I agree with you and I put you back into the same room at the table again, what are you going to accomplish? If everything has changed?
Actually not, Your Honor. If I could just
okay.
Explain. First of all EDC has to do is negotiate and cooperate in good faith to get to a closing on the 3 points that they said we had to meet. We will show up with the money. We will show up with the cooperation. We've already done that. Yeah. We will show up with an agreement with DBP so long as there's not some interference.
Yeah, the problem that we have, Mr. Shelley, is that I'm not sure that our role in the context of an Article 78, where we really just required to examine the arbitrariness or capriciousness of the city's position, whether we can reach that point.
Well,
it's not the city's daddy that we can just order them to, do things that they now are unwilling to do because they claim you failed to meet obligations that seem rational and that you didn't object to begin with back on December of 2018.
The obligations were not the problem. The problem was that they frustrated our ability to meet them. And so yes, it's not rational for the government to block you from doing what they've asked you to do.
How would that change if we forced you back to the arguing table?
I think a grant of the petition from this court and a clear instruction to act in a commercially reasonable way, we would have the deal done in no time, Your Honor.
Don't you think the city's empowered to change plans and do things differently?
Yes, but not in the middle of a deal with us. That's the issue. And let me say, on the property, it's important to note that here's what really happened, okay? Somebody, and we believe—
I'll give you 30 seconds for that, Mr. Shelley. You're way over.
We believe that EDC and the neighbor got together and decided they did not want a garage under the park. So they sabotaged our deal, and now they have a park and no garage. If we win this appeal, Your Honor, we're going to go back and we're going to negotiate. And if they act in good faith, this deal will close. And if it doesn't close and they've acted in good faith, then that's on us. That's fair. Last thing, just one more sentence, Your Honor. We at least have a right to discovery. Judge Edmeade was just wrong about this. We're entitled to discovery. We've shown that there's a reason for it. We think there was some conspiracy here, and at least send it back for that purpose, if nothing else.
Thank you, Mr. Shelley. Thank you all.
Thank you.
227 West.
Good afternoon, Your Honors. Paul Allo, Contract and Allo LLP. For the appellant, Walsum 61 LLC.
Do we have our respondents to 227?
It's Scott Mullen, Herrick Feinstein for the respondent. Good afternoon, Your Honors.
Thank you, Mr. Mullen. Let me hear from Mr. Allo.
Thank you, Your Honor. So I'd like to address, there's three separate points, each of which we think compels reversal of the order, the decision below. First, we think that co-finance sued the wrong party. Second, goes to the construction of Section 511B. And three, whether or not this is, the real property law allows the fee sharing. So let me address the first issue, which is whether they sued the right party. So this is a limited liability company. Co-finance essentially had a carried interest here. They had a 15% interest because they brought the deal. The other party, the way this is structured, Walsum 61 LLC, my client, is the other 85% member of that entity. David Burley is the manager. So when they sued Walsum, so this is a provision in the operating agreement that requires, which contemplates that it might be, it's not, they're not exclusively, that Walter and Samuels, which is affiliated with Burley, would be, might receive a commission and receives a portion of that commission where there's participation. I'll get to that other issue.
That takes us straight into interpreting 5.1.
Correct. Let me, if I can just deal with one issue at a time. So Walsum itself is basically a pool of investors, many of whom are well known. They're 85%. They're not the one who is obligated to pay this money, no matter how you slice it or dice it.
Counsel, I don't mean to interrupt, but let's get to the heart of the issue here. Let's assume that they didn't sue the wrong party. Get to 5.11, because that's the critical issue, is whether or not that agreement is ambiguous or not. Yeah. The Supreme Court below found it was not ambiguous. Right. And that the way the Supreme Court put it, it's either two versions: enough is enough or a deal's a deal. And Supreme Court took the position, a deal's a deal. So let's get to that part. That's okay. The key part, right?
So this is the language. We do agree that there's no argument here that that 61 owner is bound by this agreement. We think they are. And we're not arguing that, apart from the real property law, we're not arguing whether or not this is enforceable or a deal is a deal. But if you read the language and you read the language carefully, what you'll see is that there is a portion, and the portion is determined to the extent of co-finance's involvement as agreed to by a member of the company, agreed to by the members of the company. So when you look at what happened here, factually underlying this is that when co-finance brought the deal, they were under extensive negotiations with the school construction authority. That was 20 pages of notes. Mr. Maurer, I deposed, and they were heavily involved in this. So they were clearly participating in that deal. In the first round, they actually did get 25%. They were factually.
So I think is there a time limit? I'm sorry. Is there a time limitation on getting that 25% in the future?
So if there is a future deal, it would apply to an extension or a new lease. So we're not arguing.
So I'm looking at the language of 5.11 and the entitlement to the 25%.
Right. So I think the answer to that is no, but I think that if there was a future transaction, then you have to look at it transaction by transaction. In other words, there was a transaction in 2010.
And you based that on what? You based that on what? On the language of the agreement?
Correct.
Where does
any
it
leasing commission, right. So if you look at the whole agreement, so the reason I would have to agree with you is if you look at the whole agreement, the first part of it talks about leases procured in whole or part by the property manager, which is WSI. And then there's a fee schedule for them. So if that's triggered, then the second part of that language is then triggered. So I would agree with you that if in 2010 there was a transaction, 2016 there's a new transaction. We're not arguing that this language cut them off.
Counsel, I think your argument, correct me if I'm wrong, is that in order to get that at least no less than 25%, the plaintiff had to have some sort of participation. They can't just sit back and collect money. Is that your argument? Is that what you think 5.11 says?
Yes, that's exactly, Judge, that's exactly right.
Right.
And where does it say that in the agreement?
So if you go to the agreement, it says they're going to be paid a portion, and then it defines a portion on the basis of the extent of co-finance's involvement as agreed by the members of the company. So that's where the language comes in about the participation. The word portion is used twice, and the second part of it makes clear that it's based on their involvement. So that's where the language comes in, which again is consistent also with the parties' actual behavior here, which is that at the time that this deal was put together, Jim Maurer of Co-Finance was heavily involved with the school construction.
Counsel, but that paragraph that we just looked at,
correct,
is that the word portion is used twice.
Correct.
And the second use of the word portion is amplified, or at least explained by saying the extent of co-finance's involvement, right?
Correct.
So you're saying that there has to be some involvement in order to get the minimum 25%, correct?
Yes.
But it doesn't say that. It just says to the extent of co-finance's involvement, which cannot be zero. It doesn't say that. It just says to the extent of co-finance involvement. So if there's no involvement, then how do you get around? It doesn't say that. It doesn't say what you're saying it says.
Well, it doesn't say either explicitly if there is that they would get at least 25%, and they would get more if they were involved. It doesn't say that either.
You don't think that that's the reasonable, in fact, like literally the only reasonable interpretation of that provision?
No, we don't think it's a reasonable interpretation.
You have to pay if that's the only reasonable interpretation.
Well, look, these guys that cut this contract knew what they were doing. 25%
plus whatever you do.
Well, Your Honor, actually, there was extensive testimony and deposition testimony of Peter Weiss, who was the person who negotiated
But we
this.
don't, Mr. Allo, we don't get to that if we find the language of the agreement
Correct.
unambiguous, right?
I'm simply saying, I'm simply responding to the question, Judge Scarpalla's question, which was, what did the parties who write this intend? They did not intend, or at least did not intend this, and we think the language supports them. I mean, you know, could this language have been written better from both sides? Obviously. But we think the language, and we think that at the very least, there's two reasonable constructions. We think it's obviously in all these cases, everybody says, I'm right and the other side's wrong. But, you know, when you're dealing with language like this, we think that there is at least one reasonable construction of what it was. And again, so I don't know if did I run my 6 minutes?
You have 8 minutes and 37 seconds so far. So
okay. Well,
let me hear from Mr. Moling, and then you
okay.
have a minute coming back on rebuttal.
Again, good afternoon, Your Honors. Justice Cohn's decision reflects his puzzlement as to how the words "not less than" can possibly be ambiguous. That's why he said, number one, it's unambiguous. At number two, and unambiguous in the plaintiff's favor. Number two, even if it was ambiguous, all of the circumstantial evidence supports the plaintiff's position. Not less than 25%, which is why that was paid the first time in 2010. Course of conduct is very important. If I can inject a moment of humor during a difficult time, there's an old Italian expression, which is watch the hands, not the lips.
That's the three-card Monty.
Yes, it's a way of showing how people interpreted, understood what the agreement required. And in 2010, the lease itself specifically said the lease was negotiated solely by Walter Burley, David Burley, and Walter and Samuels. Same thing in 2016. So the idea that this excuse that Mr. Maurer had to be involved in the lease negotiations in order to trigger a sharing is just contradicted by the record. You can't find it in 511. There's not a word that talks about a minimum amount of involvement. And in fact, the lack of involvement totally undercuts their position based on Real Property Law 442, because it is uncontested in the record that we do not have a situation where someone was holding themselves out as a broker, where someone was rendering services as a broker and never had a license. The cases that are relied upon by the defendant, some of which the cases members of this panel sat on, either involved a licensed broker who was not the procuring cause, or an unlicensed person who was a procuring cause. In this particular, you did not have a situation like this, which the Cavian case directly addressed, which said there is no danger here that the public could be hurt by someone rendering brokerage services without a license. And in fact, if that were the case, based on the wording of the agreement, they violated the law in 2010 by paying us, because the agreement said it was negotiated only by them.
That just means to me, Mr. Mullen, that you're saying that, you know what, if they're going to take the position that 442 stands as an impediment, then my client's not going to do anything at all going forward in the next 10, 20 years, because I'm okay with this deal. The deal says minimum 25%. And if it has to go above 25%, I have to participate. But then again, if I participate, I might violate 442. So I'm not going to participate. Just give me my 25%.
Or we could hire a broker and participate as a licensed broker.
Why are you going to go through that effort if you could just sit back and someone gives you 25%? That's not a bad deal.
You're absolutely right. And if one reads the deposition, of Mr. Weiss, you can see that he's clearly unhappy with the deal that they made. But what they don't...
Well, like Judge Cohen said, enough is enough.
That's right.
But Judge Cohen took the approach, a deal's a deal.
Yes, and by the way, just so we are clear, because they really don't acknowledge it, this company, Co-Finance, the respondent here, they found this deal. They identified the deal. They negotiated the deal. They put just over $2 million of their own money up to tie up the deal. Then they brought in the appellant. They gave them an exclusive management contract, which was increased from $25,000 to $50,000 a year. And they made them the exclusive leasing agent. This is not a city that doesn't have other leasing agents. We have Cushman Wakefield, Jones Lang, we have Newmark, we
got plenty.
We got plenty. So they got lots of benefit from making this particular deal. And their excuses have been inconsistent. Number one, it only applied to the first deal. However, 511 says, or any other lease. That's what 511 says. Number two, at oral argument, they said, we're not arguing that it applies only to the first one. That's at 473 of the record. Then they said the 2016 deal was not an extension of the underlying lease, but the lease's title says Second Amendment and extension at 203. So they just misstate that. Then they say that we're required to have a license, real estate license. It doesn't say that. Then they said it requires Mora's involvement. It doesn't say that. Then they say we sued the wrong party. Let me address this suing the wrong party.
I'll give you 30 seconds, Mr. Mullen.
I need 15.
Okay.
The whereas specifically said the members agree to these terms. Number two, the members signed the agreement, the LLC agreement. Number three, the testimony of the controller of 20 years was he was directed by the member. So this is very different than a case where an LLC only agrees and then you sue a member. It's very different from that kind of situation. And I'll just end, if I may, by providing what I think is a window of insight. Mr. Weiss, when testifying and confronted with his own CFO's email saying that 25% is supposed to go to the respondent, his comment was that this Mr. Hess was a, quote, rambling, nervous man who basically is just, for no apparent reason, sending me documents. Of course he was nervous. His boss was trying to cheat a partner. I'm done.
All right, Your Honors, I want to stay away from. I'm going to stay away from.
About 1 minute.
Yeah. First of all, let me deal with the course of performance conduct argument, because the record is directly contrary. Maurer was completely and heavily, was exclusively really dealing with the school construction authority on the first deal until he told them he was going to throw the New York City school out, and they said they were going to condemn the property. And from that point on, he was not involved. But the record is absolutely clear, quite to the contrary of what was said, that the course of conduct was 100% opposite to what Mr. Mullen is referring to. And Mr. Weiss also testified that he had no clue that Mr. Maurer and Co-Finance, who was doing that, didn't have the requisite broker's license. So it wasn't their testimony is they didn't know that he was unlicensed, which almost everybody who's in this business and dealing with this would have the license. Dealing with the language.
Your minute is up, Mr. Allo. So please.
Okay. Dealing with the language. So the word portion. So he transposed the language. Okay. The language is portion, and portion is modified, is defined in the second portion, in the second part, I shouldn't say portion, of this agreement. So you have to read both halves of this agreement, which is in the basis. It doesn't say what they're saying, which is portion. And again, the course of performance and the relationship is, nobody dreamed that Co-Finance, that Maurer would get thing, that they would have zero involvement, because that was not their thing. And in terms of the Kavanagh case, that deals with a completely different situation. Thank you.
Thank you so much. Bye-bye.
Thank you.
Last case, thank you both.
Thank you very much.
We have Rodriguez versus HPD and Stevenson Commons. Okay, for Appellant Rodriguez.
Yeah. Good afternoon, Your Honors. May it please the court. My name is Andrew Jones with Mobilization for Justice, and I represent the appellant, Yvonne Rodriguez. Ms. Rodriguez is asking the court to overturn.
Just give me 1 second. Do we have the parties for HPD and Stevenson Commons?
Yes, Ellen Ravitch for HPD.
Heidi Brumond for Stevenson Commons.
Okay, thank you. Go ahead, Mr. Jones.
Okay. Good afternoon, Your Honors. May it please the court. My name is Andrew Jones with Mobilization for Justice, and I represent the appellate, Yvonne Rodriguez. Ms. Rodriguez is asking this court to overturn an HPD administrative decision that rubber-stamped the landlord's efforts to evict Ms. Rodriguez, namely because she cares for her mother. Ms. Rodriguez is a nearly 20-year resident of a Mitchell-Lama apartment. She maintains such hallmarks of permanent occupancy in this apartment, such as she has a dog in this apartment and has a landline. Ms. Rodriguez is also her elderly mother's primary caretaker. Ms. Rodriguez occasionally stays with her mother, as is fully within her rights.
What about the document she executed for Ms. Caballero? I mean, I don't think that, I mean, I know you want to characterize it as, you know, the fact that she's living with her mother as being the underlying basis of the lawsuit, but the reality is that she was not residing in the apartment as her primary resident, right? This wasn't a casual visit to her mother. There was somebody else in the apartment, right? So can you address that, Ms. Caballero, and the agreement that she got for the payment of $700?
Yes, Your Honor. The hearing officer's sole finding was in regard to a non-primary residence case. There was no finding of an illegal of any type of sublet. So in this case, what's key in this case is that the hearing officer is the due process issues. At the HPD hearing to review the landlord's allegations that Ms. Rodriguez is now using this apartment as her primary residence, Ms. Rodriguez testified to the facts just stated, but the hearing officer disregarded this testimony and fixated on largely irrelevant facts, namely a single letter suggestive of the sublet, but not the non-primary residence case. Furthermore, the hearing officer failed to aid Ms. Rodriguez, an unrepresented and unsophisticated litigant, in a manner that would ensure there's a full and complete record in this case. So essentially, hearing officer...
Let me interrupt you. One, it wasn't just a nothing letter. It was a sworn letter by your client stating that somebody else was living in the apartment. It wasn't just a sort of like a byproduct. It was a sworn statement by your client that someone else was living in the apartment other than her, one. And two, didn't the hearing officer give your client a list of information and say, here is what you need to submit to show your primary residency, and she didn't submit it? Aren't both those things true?
Yes, Your Honor. However, on the first point about the sublet, that suggests there may be a question of a sublet, but there's no evidence presented connecting Ms. Rodriguez to any other apartment, that she's using any other apartment as her permanent occupancy. So I'd reiterate that this case is a non-primary, the only finding in this case.
There was no evidence. There was no evidence regarding the two residences she had in the Bronx, both her mother and then another resident?
No, Your Honor. When Ms. Rodriguez testified, is that she spends time at her.
Other residents in the Bronx?
I apologize. Was there a second question?
To the hearing officer that she did, in fact, stay at another residence in the Bronx.
Ms. Rodriguez testified at the hearing is that she occasionally stays with her mother. She said 2 to 3 days a week, which, even if that was taken at face value, because that's what she said, that would mean she's spending much less than 183 days a year not at her apartment. Spending way more than 183 days at her apartment.
And now, when you look at the totality of the circumstances here, when you look at the letter that she notarized, that she signed and swore to, that someone else was subletting the apartment. When you look at the lack of documentation to show that the apartment is her primary residence because she was given an opportunity to submit that and she failed to do so. And then when you look at her testimony that she does in fact stay at another residence, even, you know, accepting what she said 2 or 3 times a week, you know, it leads a trier of fact to conclude this is not her apartment.
No, Your Honor, I would respectfully disagree for 2 main reasons. The hearing officer's decision mischaracterizes Ms. Rodriguez's testimony and therefore is arbitrary and capricious. And it's also based on an incomplete record, as it's not supported by substantial evidence. So on the first issue that it isn't support that it's arbitrary and capricious, the hearing officer's decision is made without regard to the facts of this case. The hearing officer's decision ignores the testimony on page 21 of the transcript, namely that she cares and stays with their mother, and also admits the facts relevant to her permanent occupancy at her apartment, that she has a dog at the apartment and has
Your time has elapsed, Mr. Jones, but I'll give you an extra 30 seconds to finish up that second point.
Okay, rather the hearing officer's decision cites to quotes out of context, and I also want to get to the cites to quotes out of context, even though she elaborated on the testimony. And also, I want to repeat that to 2 to 3 days a week. That would mean that she's still spending the vast majority of the time at this apartment. And then I also want to address the substantial evidence issue. In a case where there's not represented.
I tell you what, Mr. Jones, I just wanted to let you finish your second point, not to start the argument with respect to the 2 points. So you've already argued for 8 minutes and 35 seconds. So I will go to Ms. Ravish, and I'll let you. You have 1 minute rebuttal. I'll give you an extra 30 seconds on that. Ms. Ravish.
Thank you, Your Honor. I'm here today on behalf of HPD and Respondent Enderlin. HPD's determination to issue a certificate of eviction here is supported by substantial evidence and should be confirmed. The housing company presented evidence, the letter that has already been referred to, of an impermissible sublet, and Rodriguez failed to carry her burden to show that she'd maintain the subject apartment as her primary residence. The rules of the City of New York require a tenant of a Mitchell-Lama apartment to occupy that apartment as her primary residence.
Yeah, Ms. Ravitch, what is the evidence that she resides either with her mother or in another place in the Bronx? I wasn't clear about the nature of that evidence, because that seems to have influenced the hearing officer's determination.
Your Honor, my reading of the hearing officer's determination is that that was not a basis for the determination. The determination was made because her primary residency was put in question by the letter, and then she failed to meet her burden. It is her burden to show primary residency. And to the extent that Ms. Rodriguez keeps talking about that the record did not contain substantial evidence, the substantial evidence consists of the fact that she did not establish her primary residency when it was put in question. Both the rules of the City of New York at 28 RCNY 302N44 and this court's, as recently as February of this year, determination in another case called Rodriguez, which we cite in our brief, have consistently held, or the rules provide and the courts have consistently held, that it is the tenant's obligation. That is part of her obligation as a Mitchell-Lama tenant. That when her primary residence is put into question, she must prove it. So the elements, what the petitioner calls here the 4 factors that she alleges the housing company must establish, that's not an accurate reading of what the rules are. Those 4 elements that are listed in the rules are facts and consideration, facts that should be taken into consideration in determining primary residency. But there are things that she must establish, and she didn't do any of that here. And that's why the determination here is supported by substantial evidence. It's her lack of evidence. Yes?
No, I'm good.
So she makes this argument that because she denied the truthfulness of the notarized letter that she signed, and which she admitted in her testimony was to help her friend scam HRA, another city agency. But her testimony that she lied in a notarized statement certainly was not enough to establish her primary residency, again, which was her burden. They now make repeated claims that she was not given an opportunity or told what she needed to provide, but the hearing transcript completely contradicts that. Starting at page 32 of the hearing transcript, there's a several-page discussion with Ms. Rodriguez between her and the hearing officer, telling her how to submit evidence, what kinds of evidence she needed to submit, and the hearing officer gave her a list of that evidence, of possible documentation, which is at Exhibit G of our answer. Now they raise due process arguments, which were not part of the petition here. And
we're quite familiar with H.O. Lipa's exchange with Ms. Rodriguez, so
yes.
You don't need to go over that.
Right, and so just on the due process argument as well, it wasn't raised in the petition, and in any event, the hearing transcript again shows that there was no due process violation, as is discussed in our brief. So in the end, we just ask the court to confirm, because Ms. Rodriguez did not meet her burden, and the determination is based on substantial evidence.
Thank you, Ms. Ravitch.
Thank you.
Okay. Counsel for Stevenson Commons, I saw you disappear for a second.
I did disappear, however, I've reappeared again, like many things in this world. It's Heidi Brumond from Doyle and Brumond on behalf of the respondent, Stevenson Commons Associates. Again, I disappeared. Somehow the computer blanked out, so I'm on my phone, and I apologize for keep going in and out. Your Honor, I did the hearing myself, and basically, simply, Ms. Rodriguez attended the hearing. She started off by saying that Ms. Caballero did not live with her, did not stay with her, was not there, even though the letter was in the evidence. She then, when I questioned her, changed her story and said she was there for like 20 days. And that kept going on until I presented her with the fact that Ms. Caballero had brought the papers to us in February of 2018, which was 4 months after the claim Ms. Caballero had left. And I questioned how she could even have the non-payment petition and the documents to come to our office. With a little bit of back and forth, suddenly, Ms. Rodriguez says, well, somebody else was living with her too. Someone who she had, and she acknowledges lived with her for at least 6 months. Now, whether it was more than 6 months, I don't know at that point, but she admitted it was more than 6 months. She admitted that she and Ms. Caballero had together come up with this idea of going to HRA and getting money that's double what her actual rent is. She, in the hearing, states that she never charged rent, never got any money, and that's on page 22. However, in her affidavit attached to the Article 78 proceeding, she states that Ms. Caballero did pay her rent. Again, and in that Article 78, which is interesting, is that they annexed documentation, which they shouldn't have done and weren't allowed to do, which was to try and present that this apartment is her primary residence. Again, none of those documents that now she has an attorney and are submitted as part of an Article 78 that wasn't part of the record below, wasn't part of the record at HPD, established that she had this as her primary residence. In fact, one of the documents that's annexed is a medical form, and it states that she changed her address March of 2018 to this address. So after this case was already, not March, sorry, after this was already done, about 3 months later, she changes her address to this address, the address of Stevenson Commons. And they annexed that to their picture, to the Article 7 to demonstrate that she actually resides here as her primary residence. I believe that HPD's decision was correct. I believe that the housing company had sustained their burden of demonstrating that there was an illegal sublet and that Ms. Rodriguez sustained her burden, demonstrating that this was.
Thank you. Thank you, Ms. Roman.
Thank you.
Okay, Mr. Jones, you get the last word. You get a minute in rebuttal.
You're muted.
Yeah, again, I just want to reiterate, this is a non-primary residence case, and there's no evidence connecting Ms. Rodriguez to any other apartment. This is not a sublet case, it's a non-primary residence case. On the substantial evidence argument, it's clear from the transcript, Ms. Rodriguez did not understand the concepts of cross-examination, objecting to evidence. The hearing officer allowed the landlord's counsel to take advantage of the case, ask misleading questions, and ask leading questions of its own witness. The hearing officer failed to independently inquire about the facts at all. When instructions were provided to Ms. Rodriguez, she had non-responsive answers. There was not a complete record on this case, and it could not have been based on substantial evidence because there's no full and complete record. And as to the four factors that Ms. Ravish related to, there's only allegations concerning one of the four factors, the sublet. There's no even allegations of the other three. The landlord had an initial burden that to question Ms. Rodriguez's tenancy. That wasn't there, and this case is also not based on substantial evidence because there was no initial finding. The burden was improperly placed on Ms. Rodriguez. And some people should not be evicted for caring for their parents. The hearing officer's decision mischaracterizes the testimony, it's arbitrary and capricious, and it's based on an incomplete record, and therefore is not based on substantial evidence.
Thank you, Mr. Jones. Thank you all, and this concludes oral arguments for the day.
Thank you, Jeff.
Thank you. Have a good Thanksgiving.
Thanksgiving to everyone.
Thank you very much.
Thank you all.
Bye-bye.
Happy holiday.